Uh, May I please, my lord? My lord, I beg to mention item number 5.
Criminal appeal.
Yes, yes, my lord. We have received a paper book recently only, my lord. So matter may be fixed after, listed after vacation, my lord.
Item 5. Both sides are represented. On the prayer made by learned counsel for the appellant, matters to Judge John today. List after ensuing Durga Puja vacation.
Deeply obliged. May it please your lordship. Your lordship, on last occasion, your lordship, the matter was actually admitted. It was admitted long time back, your lordship. It was directed to be listed for hearing in usual course, your lordship. But again, it
There
has
was an
been
order to issue notice to the
victim.
victim.
Your lordship, that part has been, your lordship, adjudicated by this honorable court on last date, your lordship. I have raised this issue, but since there is no any family member there for the victim, your lordship.
Oh, she is married to the accused.
Yes, she was orphaned as per the observation of this honorable court, your lordship.
Okay.
Your lordship, the order dated 25/6/24.
Yes, yes, I have seen that. This is for hearing then.
Yes, your
It has
lordship.
been admitted.
In usual course, your lordship.
Okay. The learned legal aid counsel for the appellant is absent on call. Mr. T.A.K. Learned additional TP has submitted that by order dated 7/11/2023, the appeal has already been admitted. Next, whereas the paperwork is ready. This is the matter for. Oh, acha, but just not. There's a list of legal aid counsel. Yes. Legal aid. Legal aid counsel. This is. Feasible to. Okay, notice not to. Okay. So accordingly. As issuance of notice of the victim. It's been dispensed with by order dated 25/6/2024. This is the matter for hearing after the ensuing long vacation.
Yes, Your Lordship. Deeply obliged. Lordship, here we are directed to verify the address of the victim respondent, Your Lordship. So we have communicated the concerned authority, and Your Lordship, they are verifying the address, Your Lordship. Your Lordship may await for the report, Your Lordship.
But there is long back 13/5.
Yes, Your Lordship. Today also, Your Lordship, I telephonically communicate them, and they just inform me they need further time, Your Lordship.
Okay. So yeah, I'm the senior counsel assisted by Ms.
Ye lawyer, Your Honor.
E.
Ye lawyer.
K. Loya. Counsel for the appellant is present. Mr. T. Leonard AVP has submitted that he has telephonically interacted with the officer in charge from Zero Police Station, who has sought for some more time to provide the address verification of respondent number 3. Accordingly, matter stands adjourned today. Next person. The learned AVP shall send a downloaded copy of this order to the officer in charge, Zero Police Station, to ensure that the verification report regarding address of respondent number 3 is transmitted to him, transmitted to the learned APP at least a week prior to the next date of listing. Next one, list on when?
Your Lordship, after puja break, Your Lordship.
List on 6/11/2024.
Okay. Deeply obliged.
6/11.
Your Lordship.
Yes,
Your Lordship, today only I have served the copy upon all the government.
no, but
respondent.
what about steps on respondent number 9, 10, 11? You're not taken.
Lordship, for this, I may be allowed to take fresh step, Your Lordship.
Okay, you got copies? Ma'am.
Today I have it.
Okay. The learned counsel for the petitioner submits that a copy, the requisite extra copies of the of this PIR has been served on the learned government advocate as well as the learned counsel for the various state agencies. Union of India. You have got copies?
Madam, respondent number 1.
Okay. Next slide. The user write the presence of Mr. L. Parme, Mr. M. Kato, DSGA for respondent number 1, and Ms. P. Pangu, government advocate. You are for respondent numbers
3 and 4, Your Lordship.
3 and 4. And Mr. Parme, you are for
I'm for 2, 5, 6, 7, and 8.
Two, five,
five.
six,
2, 5, 6, 7, and 8.
6, 7, 8. Okay. Next, the learned counsel for the petitioner, petitioner pays for and is granted 2 days time to take steps for service of notice on the respondent numbers 9, 10, and 11. By registered post with AD. The notice is made returnable on 6/11/2024. This number 6/11/2024. Hold it.
Mayor, your lordship. Lordship, this I application has been filed for condoning of delay, 31 days of delay, your lordship.
71.
31, 31. 31 days delay.
Have you served notice on the respondent?
Yes, your lordship.
ma'am. So you are appearing?
No, sir, I'm not, I have no idea. I have no idea.
No objection. Okay. Heard Miss Ann Anjul and counsel for the applicants. As well as Mr. H. Lampul and counsel for the opposite parties. By filing this application under section 5 of the Limitation Act, all the applicants have paid for condoning the delay of 31 days beyond the period of limitation in filing the connected appeal against the judgment and order dated 11/6/2024, passed by the learned single judge of this court in WBC 376 AP of 2024. Next one. The learned counsel for the applicants has submitted that some time was consumed by the applicants in taking an appropriate decision. And they were also engaged in performing certain official duties at Guwahati, for which there was an inadvertent delay of 31 days in filing the connected appeal. Next one. Although the learned counsel for the opposite parties has objected to the prayer made, considering the explanation given, the court is inclined to accept the same at good and sufficient cause, which has prevented the applicants from filing the connected appeal on time. Full stop. Accordingly, next paragraph, accordingly, the delay of 31 days beyond the period of limitation in filing the connected appeal is condoned. Next paragraph, this application stands allowed. Next paragraph, the registration now lists the connected appeal for appeal in the admission columns.
Oh, bless. It's not an unlisted matter, judge for judgment pronounced.
This application is allowed, the FIR is quashed. It is clarified that nothing contained in this order shall be constituted to be a finding of fact in respect of any suits or proceedings that may be pending between the parties.
Deeply obliged, Your Lordship.
There's some minor corrections to be released in the evening.
Okay.
I was telling, I just remember my school days. When we were in school, class 4, 5, and this way, the results would have been announced by roll number 1 pass, roll number 2 fail. May it please your lordship, item number 26 and 27.
No,
My
this
lord.
also can be dispensed with. We are now in a modern world. We are in the age of change. If the bar gives us a resolution that they would not insist on an open court pronouncement, we would be happy. Yes, item
Item
number
number 26 and 27, my lord.
26, 27.
26, 27. My lord, can this matter, my lord, all the pleadings have been completed in this case. Nothing is left now. So let it be fixed on 24th and 25th, both the 2 days, my lord. 24th and 25th October, no, but there
October.
has some order, October.
Not, we'll continue, we'll take it up next week because many matters are being deferred.
24th,
In this week.
25th of October.
No, we have already fixed many matters. In these 2 weeks, we have been fixing many matters immediately after the Puja vacation. We can
I
have
think
it in
my
the week
AG
commencing
AG is also-
28th of October.
Huh.
That week we can consider
28.
28th week, whenever you want.
28 is Monday.
Week commencing 28th, whenever you want.
No, it's okay, fine, my lord. There is
28th is,
28 is.
would it be 29th, will not be Tuesday?
Krishna.
29th?
Twenty-eight,
Okay.
subject to AG will be there, na?
Yes, AG.
He'll be there. Yes, yes, right.
Okay.
So only
All
one
states,
request, my lord. The pleadings are completed. That's your lordship will kindly know. Pleadings complete, nothing is there to more.
okay.
Yes.
Mr. D. Das, London Senior Counsel for the petitioner in WPC 230 of 2024 submits that the readings are completed and matter may be fixed for hearing. Mr. D. Kamduk, London, Counsel for the Land Management and for government who will be there.
AG is there, my lord.
Huh?
AG is there, my lord. AG.
No, but AG is not here.
No, he'll be coming on this.
No. I'm writing of the presence today.
Not today.
Miss T. Bangmore, government advocate is present. Full stop. Your form?
Sign for NHPC in WPC 230.
Okay.
And our writ petition is 242 AP of 2000.
You also had Mr. E.K. Tiwari, London Senior Counsel, assisted by Mr. K. Saxena, Counsel for petitioner in WPC 242 of 2020 is also present. Full stop. Next para. As agreed to by both sides, list the matter for.
Pleading completed, ma'am. Pleadings.
So we will admit it and fix it for here. It's already for hearing.
Pleadings.
List the matter for hearing on 28/10/2024.
Only once a request will be made before the court for upgrading the matter because all the
But you
time,
make it
whoever, your lordship will just make an observation, otherwise.
We are not making, you make a mention, you know, all the, you know, the. court
Or
ordinance.
it may come up for admission hearing.
No, it's already for hearing.
Yes. It's
It's in
okay.
the column of hearing.
No, it's okay. Fine.
It's in the column of hearing.
Yes. Deeply.
Your Lordship, may I please, I beg
Yes.
to mention item number 8, Your Lordship.
Item 8.
Yes, I am mentioning on behalf of Shri Nitin
Just-
Khera.
Just a moment. Just a moment. Item number 8, yes.
Yes, Your Lordship. I'm mentioning on behalf of Nitin Khera, Your Lordship. There's a bereavement in his family. So I seek Your Lordship accommodation.
Okay.
If Your Lordship may kindly have it on the
Okay,
24th.
you are for the petitioner or the private respondent?
Respondent number 3, Your Lordship.
Respondent 3, okay.
This for respondent.
Okay. Both sides are represented. on behalf of the learned counsel for the petitioner, regarding respondent number 3, it is submitted that the learned counsel is in bereavement. And accordingly, prayer for adjournment is made. Full stop. According to matter stands adjourned today. List.
If you can
It
have
goes
on
after-
24th of October, Your Lordship.
25th October.
All right,
2022.
Your Lordship. All right. Your Lordship, similar prayer for item number 22 and 23, Your Lordship.
22, 23.
Your Lordship.
Okay, you have taken consent of the other side?
Yes, Your Lordship. Here he is a standing counsel for Power Grid, Your Lordship. The-
Okay.
Your Lordship, if
Item
you can have,
22, 23, anybody is there? Item 22, 23, a prayer for adjournment? Okay. Both sides are represented. This is same prayer. For the
you
practice
can have
matter.
21st, Your Lordship, this matter.
Hmm?
21st
21st of?
October.
No, 21st is a week where you have fixed many matters.
All right, Your Lordship. All right. You
We
can have
fix it on
25th.
30. If you want, we can fix it on 30, 30.
30. Then we can have on the 25th, Your Lordship, on the same date.
Huh?
25th, the same date as the previous matter.
Okay, 25.
Your Lordship, it may be listed this Monday, Your Lordship, next week.
Pardon me?
Next week, Your Lordship.
Your Lordship, next week it
Next
will not
week,
be feasible.
He's
Your
in
Lordship.
bereavement.
I have been
The lawyer is
instructed.
in bereavement.
Okay.
We won't request him to come here in bereavement. Okay. Same date. Okay.
May I
Very
pray, Your
obliged, Your
Lordship?
Lordship.
Yes. My lord, I beg to mention item number 7, my lord. This matter will be taken up next week, my lord. I've taken consent from the petitioner.
7.
Yes, matter 7.
Next week, we are very close to vacation. We fix it on 30,
30.
both as a represented. On the prayer made by Mr. T. Wangwal and government advocate, matter stands adjourned today. List on 30, 9/2024.
Your Honor, I would like to mention the item number 9. Item number 9, Your
Court
Honor.
has to be buttoned up. Court has to be buttoned up. Court has to be buttoned up.
Yes, Your Honor.
Yes.
Your Honor, I would like to mention the item number 9.
Yes.
The matter may be fixed 30th of September. Your Honor, respondent has instructed me to fix for the 30th of September.
Pardon me, I did not get it. Please repeat again.
Yes, Your Honor. Your Honor, respondent counsel has instructed me to the fix for the 30th of September. Because she is came from the Guwahati.
I'm still not getting you. Please repeat again.
Your Honor, item number 9 is
Yes.
yes. Your Honor, responding counsel has instructed me to fix for the 30th of September item.
30 September.
Yes, yes.
Who is appearing for the respondent?
Your Honor, R. Sonar. She is from the Guwahati High Court. Guwahati SCB. She is standing counsel. She is
Name?
R. Sonar. R. Bora. Sorry. R. Bora.
R. Dwara.
R. Bora.
Bora.
Yes, sir.
But his memo appearance is not there. We don't find his memo appearance being filed. Oh, acha, Miss R. Bora.
Yes, Your Honor.
Okay. Okay. The land counsel for the petitioner submits that he has received request from Ms. R. Boradan, counsel for respondent numbers 1 and 2. For adjournment of the matter. Matter since adjourned today, list on 30/9/2024.
Much obliged.
Your Honor, I beg to mention an item for listing tomorrow.
Item,
It's a contempt case, 24/2024.
new matters.
Sorry, Your Honor.
This is why there is an urgency?
The urgency is that, Your Honor, my salary has been withheld for 3 months, and I have 2 minor children to take care of.
Okay, permitted.
Much obliged, Your Honor.
Well, Lordship, I would to mention one unlisted matter. That is WPC number 551 AP
What is
23.
the urgency?
Lordship, for withdrawal, for listing for tomorrow, withdrawal, for withdrawal,
Okay.
for listing for tomorrow. Obviously.
Lordship, may I please to mention for one unlisted IA, my lord.
Oh,
For unlisted motion today, my lord.
no, what is the urgency?
Urgency, my lord, this pertaining to transfer posting matter. And Lordship has passed the interim order providing liberty to the state respondent of a certain such an eligible officer can be transferred. In this case, I am I'm already eligible as per the condition provided by Lordship. So that fact was earlier. Okay. Possible.
Yes.
On the last occasion, I was instructed to submit a representation before the Commissioner of Health and Family Welfare, and accordingly, I have submitted
Where
the
is your certificate? Where is the medical certificate? Where is the medical certificate?
Oh, my lord. Yeah, it's an it is my lord at page number 15 to 33, my lord. Page number 15 to 33.
15 to
33
33.
is a medical records.
In this matter, we'll take it up after some time. You please consult someone and tell it, because although you are projecting that your wife is suffering from mental disorder,
Yes, my
but
lord.
under the Mental Healthcare Act, it must be an institute which is authorized to give such certificate. It must be a the person must be authorized under the act to issue such certificate. Otherwise, nobody can declare anybody to have a mental disorder.
My
It has to
lord,
be squarely within the meaning of that act. Mental disorder, there is a prescription given as to who would be the competent authority. So you'll have to show us that he is a competent authority. You may interact with your petitioner and then tell us how this, how this prescription can be accepted to be a proof of mental disorder. Because under the act, there is a prescribed authority to give such certificates. And without, in the absence of those certificates, the court even cannot suggest that the person may have a mental disorder.
my lord, and at the government general hospital also, at TRIMS, there's a physicians who.
No, I'm not disputing that he has, the wife of the petitioner may have that disease.
Mhm.
But the requirement is that it must be within the, by a doctor who is, or a authority which is prescribed under the act. Please consult the Mental Healthcare Act, which is in force, and also interact with your petitioner and then come back. We'll take it after some time when you come back.
Like,
Consult the Mental Healthcare Act also.
obliged, madam.
Well, here, the basic challenge is to the action of the deputy commissioner, whereby he refused to take up the appeal and appeal against the order passed by the estate officer and remanded the matter back to the estate officer.
No, you can't do it. Whatever you have done is illegal. You can't allow that.
Madam.
This can't be done, what you have done. You have made an illegal construction over the government quarter. You can't do it.
Yes, my lord. I started construction, of course, I admit that, my lord. But in fact, when I preferred an appeal also, there also I said, since there is no quarter, I will even offer for.
You don't have a quarter, you could have come to a court asking for a direction to repair the quarter.
Madam.
But you can't demolish a government quarter and make your construction yourself.
No, my lord, that I have not demolished, my lord. That I have provided in my statement also, and in my defense also.
No, you see, in a dilapidated government quarter,
My lord,
new quarter will not just come up.
my lord.
It only happens in those video games which my kids play.
No, my lord, that I have replied, my lord, that during this rainy season, man, because it was. Yes.
You can't justify usurping a government property.
Madam, my basic prayer is only let my appeal be heard, my lord.
No,
Basically,
you
that
see,
is
what
it,
is
ma'am.
per se illegal,
Hmm.
even the equity can't be invoked.
Because, my lord, there is a statutory duty cast upon the deputy commissioner, my lord. He will decide, my lord, whether to uphold the order of the estate officer or whether we will reject it, my lord. But he has altogether, my lord, refused
Yes.
to take up the matter itself, my lord.
For government, you are appearing, Mr. Rizam?
Yes.
Yes, why your deputy commissioner is not adjudicating an appeal?
Duty of the receipt of this,
Huh?
report from state officer, he had been already warned not to continue this construction of this RCC building. He openly violated order of this.
No, but still the appellate authority must work. Is there an exemption that if the construction is,
Survey and he's, I mean, this.
no, Mr. Rizam, please show us a law
And going for this.
under your act Please show us a law that unless the illegal construction is removed, the right of appeal is not there. You don't even take departmental action against him. Sugar coated sweet boy.
Nothing can be done.
He can be terminated from service. That you don't do. That's why I told you, sugar coated sweet boy.
In fact, this appeal in original has been returned to me by the asset
No,
officer itself.
which is the act? Which volume will I get it?
My volume 8, man.
8.
8. Otherwise, I've quoted the relevant provisions, my lord, in the writ petition itself, my lord.
Which page?
Page 160 is the act, my lord.
150.
160.
60.
Yes, my lord. One six zero, my lord, and the notice was issued to me under section 6, starting from 164, my lord. 165 is the section 7, my lord, under which I have been, the order has been passed for demolition, and at 169 is section 12, my lord, which provides for appeal, my lord.
We'll take it up at 2 o'clock. You ask this petitioner to take a photograph of the premises today and give a printout to us at 2 o'clock. We want to know the status of the house. At
It
2
is
o'clock.
just only the, only
No,
the
that's okay.
basement is not the,
That's okay, but we want to know the status of the house.
my lord. As soon as we receive the notice, we have the stop the construction itself.
No, it's okay. You show us the status today
My lord.
at 2 o'clock.
May I, Lordship? Lordship, this
Yes.
if petitioner has filed this petition challenging the legality and validity of an appointment order done by the Arunachal Pradesh University, Pasigat. Your Lordship, the brief packs are 16 appointments were done in the year 2023. And there were, and these appointees, they were recruited in whose manner, Your Lordship. There were no advertisement.
Okay, I issue a notice.
Okay.
Your name?
J. Taipudia, Your Lordship.
Heard Mr. J. Tapadia, Learned Counsel for the petitioner. You are appearing for
Respondent, madam. Respondent,
which respondent?
all the respondents.
All the respondents?
Yes. My lord, in this case, university was stabilized in the year 2022. Thereafter, 2023.
No. First of all, how can you appear for the private respondents? Are you authorized? You have the wakalatnama? You have the wakalatnama?
Oh, yeah. 1 and 2, 1 and.
Now just tell us, we are asking you from whom you are appearing. 1 and 2. Your name?
T. Gadim.
As well as Mr. D. Gadim, counsel for the respondent. Please write your name. Next, brother. The Learned Counsel for the petitioner projects that without issuance of any employment advertisement, the respondent number 1 and 2 have appointed 14 multitasking staff, from 1 contingency staff and 1 data entry operator. The petitioner claims that he is an unemployed person and waiting to participate in the vacancies. Participate in the process of filling up the vacancies. Accordingly, the appointment made to the private respondent numbers 3 to 18 have been assailed in this petition filed under Article 226 of the Constitution of India. Yes, what do you have to say?
My lord, in the year 2022, Vice Chancellor was appointed. Thereafter, what happened? There was no any employee. Just to run the and functioning of the university, some of the applicants, they have submit to the Vice Chancellor by stating that they may be engaged. There was no any driver, no, there is no any sweeper. Only Vice Chancellor was there. Therefore, they were purely on temporary basis. They for 5 or 6 months they have been engaged. Now the said post was advertised, and so many people were participated in the advertisement. Now only result portion is there. Result has to be declared now.
Where is the document?
These are the admit card and attendance of the private respondent.
Where is the advertisement? Okay, then we are not issuing a notice. We'll have to dismiss your writ petition.
Your Lordship, they filed this.
Oh, it is available in the net.
Affidavit.
I am a very suspicious man. This is the advertisement in the net.
Your Lordship,
Yes, this is the court. This, the advertisement that the learned counsel is talking about is a different thing, which is issued in the January 2024.
I am holding it. I am
Yes,
showing
yes.
it to you.
Now,
It's there in the internet.
yes, now the issue that I have is the appointment which has
Oh, that
been
is
done.
gone. That is gone.
Yes, prior to this advertisement.
That is gone.
Yes, now if he is saying that this advertised posts are for in lieu of that post, which some people are working, then let them file an affidavit stating that as
We
soon
don't
as
want
this.
that. We record his statement and close the matter. We don't want
Your Lordship.
affidavits to be filed.
Now, if they are saying that this advertisement is for those posts, then they'll have to say that as soon as this result is declared, the persons who are working
He
will
is
be,
making a statement. I'll record it.
yes, that's what I'm saying, Your Lordship. The
We'll do
persons,
it, but
when this
nothing
result will be
otherwise.
declared, the persons who are working at present now, they will be dismissed automatically. If they're saying, if they are ready to give the statement, then my case is fine, Your Lordship. Otherwise, they may.
We record his statement. What happens thereafter, we don't know. We record his statement and close the matter. There is no cause of action.
Now, there is one thing, Your Lordship. The second thing is that even if they are saying that they have already notified the advertisement, then also their appointment is illegal. Because they have been working for so many days, and if they have been given chance to work even on temporary basis, even I deserve the chance to work on temporary basis. So they may need to be imposed some kind of action for illegal requirement, even if it was temporary.
Okay.
So as of today, your notice.
My lord, they have not applied for the said post.
Next, what was your name?
T got it.
T?
T got it.
How is
GADA.
it? Okay, learned counsel for the respondent numbers 1 and 2 has produced a copy of an advertisement, employment advertisement bearing F number APU oblique ADVT dash 2023 oblique 612 oblique 9 dated 19/1/2024 to project that applications were invited for filling up of 48 vacancies under Arunachal Pradesh University at Pasighat. Which includes the posts of non-teaching staff like assistant registrar, system analyst, laboratory assistant, library assistant, personal assistant, UDC DEO, LDC, driver, and MTS. I say against these vacancies are against, and against those posts, comma, the vacancies are 2, 1, 2, 2, 4, 6, 8, 3, and 20. Totally 48 vacancies. To stop, it is submitted that the appointments which are under challenge were temporary appointments which was for an initial period of 6 months commencing from the date of appointment. Accordingly, it is submitted that the petitioner, that as per his instructions, the petitioner has not applied for recruitment in terms of the advertisement dated 19/1/2024. Full stop. Next para. In order to cross-check the correctness of the averments made by the learned counsel for respondent number 1 and 2, comma, to the internet, comma, it has been confirmed that it is seen that in the internet, the said advertisement dated 19/1/2024 is duly uploaded in the website of the Arunachal University, Arunachal Pradesh University, comma, Pasighat. Full stop. Next para. As the learned counsel for the respondent numbers 1 and 2, comma, upon instructions, comma, has submitted that the appointments which are under challenge are only temporary, and those appointments would cease to exist after appointments are made pursuant to employment advertisement dated 19/1/2024. In view of such statement made by the learned counsel for the respondent numbers 1 and 2, comma, the court is unable to record a prima facie satisfaction that the appointments which are under challenge were illegal, being temporary in nature, which is followed by a issuance of a employment advertisement dated 19/1/2024. Full stop. Accordingly, this requisition is devoid of any merit and the same is closed. Next para.
Your Lordship,
However, comma, in the event any of the legal appointees and any of the appointments which are temporary in nature is continued even after the employment process is closed pursuant to advertisement dated 19/1/2024, it would be open to the petitioner to challenge such continued appointment if so advised. Stop. Accordingly, the requisition stands closed.
Your Lordship, if my petition is being dismissed, I pray that my further submissions may be recorded. I have some more submissions to give. Because Your Lordship, my condition is not the post which they have advertised. My condition is the post which they have been recruited prior to this advertisement.
That's okay. Temporary appointment we do
Yes.
every day.
Now, Your Lordship, it is a very well settled principle that in one of the case which has been ruled by our same court, the Guwahati High Court, where it is clearly settled that even on a temporary basis, it is Your Lordship, may I give the case? Yes, kindly. Thank you. Page number 214, Your Lordship, 214.
Two one for
Para 36.
para 36.
Yes, Your Lordship.
Yes.
Therefore, therefore, it is a settled legal proposition that no person can be appointed even on a temporary or ad hoc basis without inviting applications from all eligible candidates. If any appointment is made by merely inviting names from the employment exchange or putting up a note on a notice board, etc., that will not meet the requirement of Article 14 and 16 of the Constitution. Such a course violates the mandates of Article 14 and 16 of the Constitution of India, as it deprives the candidates who are eligible for the post from being considered. A person employed in violation of this provision is not entitled to any relief, including salary. This part you also. Now they are saying that they have been there was no staff and they have appointed on a temporary basis. What prevented them from being advertising even for a short period? So just
For advertisement, executive council has to be.
You didn't complete, you are running away.
So just because by saying that just to round up the university, they have appointed those persons, and then those persons are their near relatives on university. So it is totally illegal, and my right has been deprived. So now they are saying that it was temporary. If it was temporary, then who will bear up the cost, university? And who will from where shall I get the remedy? Where I could have got where I could have participated in that appointment.
Oh, okay.
So my
Next matter,
my submission, Your
before
Worship,
that
is
you write, the learned counsel for the petitioner, in support of his submissions, has placed reliance on the case of Kekshisili, Kekhrieslie, Richa, Richa, and 25 others versus State of Nagaland, and 57 others, WPC 189 of 2022, decided by a coordinate bench of this court on 29/2024. The project that in paragraph 36 thereof, it has been laid down that it is a settled legal position that no person can be appointed even on a temporary or ad hoc basis without inviting applications from all eligible candidates. Next paragraph. The facts of the said case is distinguishable from the facts of the present case in hand. Full stop. In this cited case, there's a finding of fact that out of 1140 posts of constables, only 206 posts were filled up through open recruitment, while advertisement dated August 2019, and the remaining 935 constables were appointed without any advertisement. Full stop. Therefore, in the said case, the illegal appointments were made in the year 2019, which was interfered with in the year 2024. Full stop. In the present case, the respondents have been able to demonstrate that while ad hoc of the temporary appointments were made during April 2023, and August 2023. The The employment advertisement was issued in the year on 19 January 2024. Full stop. Therefore, as the petitioner is not found to have been participated in the current recruitment process, which was initiated by the advertisement dated 19/1/2024, the Court does not find any merit. You please take it tomorrow. Please take it tomorrow. Well, huh? Because while typing, we will require it. Tomorrow you
It
can.
may kindly be reflected in the order that in view of this result declaration, the present post will cease to exist. The one which they are working.
You've already, you should have heard it when I was dictating the order.
Actually, it was not that audible, Your Lordship.
Huh?
Your voice is not that audible. You used to
It's
speak
not
that-
audible, okay. We have taken care of that.
My lord, under the vice chancellor can appoint anybody. That is given in the.
Okay, if you are arguing, then we issue notice.
Yes, sir.
Then we issue notice.
Yes, Your Lordship.
You make your argument.
Yes, Your Lordship. That will be more appropriate.
After dismissal, if you are arguing, we'll issue a notice then.
Yes, Your Lordship. I'll be obliged.
We can't help it. If you are continuing our argument even after the dismissal of the writ petition, we issue a notice, we hear you.
I'll be obliged.
We'll give you full opportunity of hearing. Check out that order. Illegal appointment, next paragraph. In view of the nature of grievance raised, issue notice of motion returnable in 4 weeks. Requisite extra copies of the writ petition be served on the learned standing council for respondent numbers 1 and 2 within 2 days. Next paragraph. The petitioner shall take steps for service of notice on the private respondent numbers 3 to 18 by registered post with AD. Full stop. List on so and so. List after 4 weeks. You take back your citations.
Thank you, Your Lordship.
Take
Well-
this. You are lucky today. And you should always learn. You see, the art of a lawyering is not to speak. It is to know when to stop.
Yes, Your Lordship. I'll keep that in mind. Thank you, Lordship.
Yes,
My lordship,
just a moment. Yes.
So may I lordship, this is a petition, a writ petition, being filed by 4 petitioner who are representing the 74 affected landowners and challenging the land availability certificate issued by the additional deputy commissioner Chang Tajo without the conducting a survey. And
Where is the memo of understanding?
uh,
Where is the memo of understanding?
a memorandum of understanding is there in page number 66, lordship. Page number 66, Annexure K. It's been available through RTI. Recently, they had given this document. And this memorandum of understanding is being signed by one illiterate 70-year-old person by declaring that the 19.20 hectares is their own personal land, whereas that's the land of those four villages. Then land,
But then this will be a highly disputed question of fact. You'll have to go to civil court to have adjudicated your title.
no, lordship, based on this MOU, subsequently, this petitioner come to know once that has been plotted online tender. Once that has been plotted tender.
See, please show us that you are the owner of the land. Somebody claims that he is the owner of the land and he has made an agreement. Now you want by a writ court that agreement should not be accepted. It's essentially a civil dispute. But still we give an opportunity. Show us where is the document that you are the landowner.
Lordship, in this regard, we had this villagers, 100 villagers had made representation to additional deputy commissioner.
No. You see, we 3 of us, we also wrote a representation that the entire half of the state of Arunachal Pradesh is our property. We have written a letter. Everybody was laughing, but we wrote a letter. We were out of the mind. It is not now. Before I was elevated, at that point of time, we gave that letter.
In this regard, Lordship, there is a handwritten statement by this additional deputy commissioner by stating that land, there was never been a survey regarding this land availability certificate. So even the department has never conducted that survey also. Just they issued this land availability certificate without any means proof and evidence. And land that the person who has signed MOU is also the clan member of that oldest petitioner.
No, that is okay. Please show us any document which shows that the land is in your name.
Lordship,
Show us any document to show that, please show us any document by which we can understand that the land is in your name.
okay. In this regard, this person who has signed MOU, along with the villager, village authority, page number 68. Page number 68.
Yes.
That's Annexure M, where means recently those villagers, that village authority has stated and nullified that the declaration made by this based on this MOU and land availability certificate has been nullified by this village authority. And village authority, they keep the record of those land in that village. And here, there were 11 village authority from that same village, that's Gaungura.
Which page was that MOU?
MOU
Page
66, Lordship.
6.
MOU is in 66. And land ability certificate is in 67. And this, whom it may concern, being declaration by the 11 village authority. Where this person who has signed this MOU, who has also attended this meeting, that's serial number 10, who has signed this MOU. He is a illiterate person and 70-year-old villagers who doesn't know about MOU. And there is a question regarding MOU also. MOU has been signed on 23rd, 2023, but it has been notarized after 8 months. That's 12 February 2024. It can be seen in page number 66 MOU that in initial paragraph on 20th day of July 2023.
Don't worry about that, because if we take this plea, at least 35% or 40% of the repetitions here would go. People sign the affidavit on a particular day, come to the notary at a particular day, and or our oath commissioner on a particular day and have this signature made.
Lordship.
Many, not one. Again, even today in the board, I'll show you 3 writ petitions. Because I have a very bad habit of reading the affidavits also.
Lordship.
That is how I waste my time.
Lordship. So land, there is no dispute regarding that land since village authority of that concerned village, they had nullified this notification and MOU.
You want to see this? See your own writ petition. Not even sworn by before a notary. Your affidavit has come like that. I told you I read. Look at this. Oath commissioner signature is not there.
So, Lordship, this is a process
We don't know. The process is that they should be before the oath commissioner. That's why I told you. Today, there are 3 writ petitions where there are this discrepancy of signature being on different date and the oath commissioners or the notary order is on different date. And yours is a case, this is the 3rd one, where there is no notary signature. It's not before a notary, neither before a
Lordship, this is the assistant registrar's signature. It's
which one?
This signature. This
Check it.
yes,
Check.
assistant registrar.
This is how affidavits are sworn. Let him see that.
Yes. Yes, assistant registrar. That's oath commissioner, designated oath commissioner. Yes.
Which one? But he has not given the seal of sworn before me. No, but this doesn't say that it's sworn before me. It's an illegal affidavit then. You have to call him. This can't happen. Thank you for pointing it out. At least I'll make that correction because this can't happen.
Lordship.
There's no endorsement that the person has sworn before me, which is an essential part of the verification process. So I was under the impression that it is not sworn. Okay, so that defect is not there. Yes.
So, Lordship, that's why there is no dispute regarding land. Actually, the person who has signed the MOU
No,
is
it's-
also declaring here.
No. He is appearing, but he's not signed it. Correct. He has not signed it.
There is a thumb impression.
No, thumb impression is not there. It's
Lord-
not there. It is for 11. Thumb impression is for 11. In 10, it is a blank. Look at your document, page 68.
68.
You were showing us page 68.
Yes. In So,
68.
yes. This
10.
10 number.
But
Yes.
in 10, there is no thumb impression. 11, there is a thumb impression.
Yes. So, but thing is that the Lordship, all those village authority, they keep record of the village land.
We don't know about that. You show us a document by which we can understand that the land is in your name.
Just for the perusal of Lordship, please turn page 69. It's map over there, which will,
This map is not a document.
uh,
Because I have a map of India with me.
Lordship, this is alignment plan of the road.
understand, please try to
Yes,
understand
yes,
my
Lordship.
point of view. Is a map a document of title?
No, Lordship.
Then you please show us something, please come here. Ashwin, under High Court rules, it must be stated that he has sworn it before me, that seal has to be there. Sworn and notarized, that seal is not here, this can't be an affidavit. Seal is not proven, sorry. No, I was.
When the point was very initial days. After calling, we put a seal.
No, it can't happen. It has to be together. Because if you sign and you are signing it, that means you sworn before you put that seal. Don't give it to our office. It would have led to dismissal of his petition. But he said that this is what the practice is. Without that seal, it can't be an affidavit. Then, sorry. Do it next time, but don't let it happen. Because I invariably read affidavits. Okay. We're just issuing a notice then. Mr. Issuing a notice.
And put a ADC Lordship. Lordship. Notice may be issued. Lordship.
What is happening, we don't know.
Otherwise.
Yes, notice.
What is happening, we don't know. You have a law in place, but nobody acts in according with the law. You have this Land Settlement Act of 2000, which says that there is a requirement of the land mutation being done. I believe you have land revenue staff.
Well,
Because
actually,
now everybody, when any development is taking place, everybody comes in groups and say that we are entitled to compensation. And you're not activating your own land revenue staff. Anybody and everybody comes and says that I am the owner of the land. You believe in the Mahaprabhu certificate. Now this is what is happening. We are also inclined to issue a notice on the Chief Secretary to tell us how this discrepancy is happening. In all development works, somebody is coming and then claiming that they are the owners of the land. There's no document. If you're not following your Land Management Act, repeal it. In this case, we are also issuing notice to the Chief Secretary.
Keep your Lordship see page 59, structure before this there inside this person.
No, you see, you please try to understand. You must take land from the proper authority. You rely on this page 66. He says that I am the owner of the land. If somebody is the owner of the land, how can third party come and claim that he is the owner of the land? Something fraudulent is going on.
well, regarding this particular package, there was already one set of writ petition. Same was disposed with direction to dispose of their representation.
You see, I am so sorry.
In the
That-
meantime, my lord,
You
in the
see,
meantime, these people,
You see, maybe perhaps there is some difference in the approach. You see, by representation, let us say that today somebody X, let us say X, he every day sees the moon, and then he says that every day since my childhood I've been looking at the moon. I think it is my property. So I write a representation to the Chief Minister. Please make a declaration that the moon belongs to me. Now, can there be an order that dispose of the representation? You accept those orders, dispose of the representation, and that is why those orders are being passed. But please tell me, how do you declare a person to be owner of the land in the state of Arunachal Pradesh?
well, in the meantime, they came
By
and they said
representation.
they have no more issues.
No, I understand, but please tell us the law. I'm not aware of the land laws of Arunachal Pradesh. That's why I'm asking you.
Yeah.
You think that I don't know the law. And therefore, I have a right not to know the law. You know that. I have made this statement many times in the court. A judge is excused from knowing law. And we have Section 57 of the Evidence Act. I'll show you again. Every citizen is required to know law. but the judge is an exception. Come to section 57, turn over to next page. I have made a pencil mark because I showed it every time. Section 57 says, facts of which the court shall take judicial notice. Correct. Now there are 13, next page, come 13. Laws of the country is also one of them. Correct. Now come to last tick mark. Please read that loudly so that I can also refresh my memory. Tick mark, please read it loudly so that I can refresh my memory.
May Lordship.
Yes, please.
If the court is called upon by any person to take judicial notice of any fact, it may refuse to do so unless and until such person produces any such book or document as it may consider necessary to enable it to do so.
Correct. So therefore you take it that I don't know the law, and therefore I'm asking you that please tell us the law in the state of Arunachal Pradesh. By way of representation, do you make people landowners? Because if you can't, then what happens in this 2000 Act? It says that the land records would be maintained, mutation orders would be passed. So what is happening to that act? It is not being implemented. Because he says that the villages have the record. Under the act, under the Village Authorities Act here, there is no requirement of a village authority to maintain records. What is the act? Village Authorities Act. What is that?
Lordship, may I?
Which page?
Yes. As per the latest 2021 Arunachal Pradesh Civil Courts Act, as per the section 3 clause E.
Don't forget about that.
Yes, yes,
I'm
yes,
asking the source of law. You said that the Gambura
yes, that's
maintains
right.
record. Under which act?
As per the 1945 regulation, they had been appointed for particular village by the deputy commissioner.
That's not the question. The
Yes.
question is, where is the duty enjoined under the said act to maintain records?
Yes, that's in that point of view. There is no written record they keep, but in particular village, all this administrative officer, they endorse those village authority. If there is any dispute regarding land, then they have been endorsed to resolve that. Based on that, in recent amendment, they have been designated as a civil judge.
Dispute resolution
Yes.
and the empowerment under the act are two different things. I am adjudicating a matter.
Yes, Lordship.
I don't have records.
Yes, Lordship.
I don't have records, but I adjudicate the matter without having the records. Correct?
Yes, Lordship.
So therefore, please understand, adjudicating something and a duty enjoined under the act. Now, can you tell me that if somebody maintains, let us say that today you say that I maintain the records of all my census of the entire neighborhood where I am living. So I am aware of the date of birth, date of marriage, date of death of any people in my locality. I live in locality X, I maintain the records. And you are dutifully doing it. Now, can that document partake a character of a statutory record?
Lordship, there is no such type of record is there in Arunachal Pradesh.
So therefore, but that's why we are saying that 2000 Act enjoins the government to do that.
Yes, Lordship, that.
So if they are not doing, somebody must answer. Everybody is now claiming to be the owner of the land. So project cost of 1 rupee escalates to 1,000 rupees.
Yes, Lord.
Then we are issuing a notice to the Chief Secretary, because this is something which has to be looked into. Heard Mr.
Kipa, Tania Kipa.
Tanya Kipa, learned counsel for the petitioners. Also heard Mr. G. Tarak Learned, standing counsel for the RWD, representing respondent numbers
1 to 4.
1 to 4. And Ms. G. A. Learned, additional senior government advocate, appearing for respondent number 5. Next para. The facts leading to this repetition is that the respondent number 6, claiming to be the landowner of 19.20 hectare land at village Hara, H-A-R-A, Yangfo, Y-A-N-G-F-O, under block Chayang, C-H-A-Y-A-N-G, Tajo, T-A-J-O, in East Kamang district, entered into a memorandum of understanding dated 27/2023 between himself and the governor of the state through one Kaku, K-A-K-U, Pangia, P-A-N-G-I-A, comma, P-I-U, comma, R-W-D, comma, Chayang, C-H-A-Y-A-N-G, Tajo, T-A-J-O, and thereby granted the said land to the state for construction of road from Tagampu, T-A-G-A-M-P-U-E, PMGSY Road to Hara, H-A-R-A, Yangfo, Y-A-N-G-F-O, comma, package number AR/03/03/012, and development of VVP Road in the village. Full stop. Accordingly, the additional deputy commissioner, comma, East Kamang district issued a land availability certificate based on which the project of rural road was initiated. Full stop. The petitioners now claim their right over the land in question. And by filing this writ petition under Article 226 of the Constitution of India, comma, the petitioners have assailed the land availability certificate, comma, procurement notice dated 5/7/2024, and for cancellation of the memorandum of understanding dated 27/2023. Next para. The sorry. the petitioners herein are not claiming declaratory right as owner of the land in question. And the prayer for cancellation of a memorandum of understanding is essentially prima facie appears to be a civil dispute. Full stop. Therefore, comma, keeping the issue of maintainability open, comma, issue notice returnable in 4 weeks. Next para, requisite extra copies of the writ petition be served on the learned state and departmental council within 2 days. Next para, the petitioner shall take steps within 2 days for service of notice on the private respondent number 6 by registered post with AD. Full stop. The notice is made returnable in 4. Next para. It is noticed from the submissions made by the learned counsel for the petitioners that meeting of some governors was held on 12/9/2024. Claiming 4 villages to have inherited the land and river. Full stop. There is no document appended to show that the land is recorded in the names claimed in the said declaration made on 12/9/2024. Full stop. Next para. From various litigations which appear before the court time and again, comma, it is noticed that after a project is being executed, the execution of any work contract is executed, comma, or initiated, comma, there are a group of people who come to the court claiming ownership right over the land on which the development work has been initiated. Full stop. This leads to burdening the court with litigations which are primarily civil in nature for adjudication of the ownership right first and then adjudicate other issues. Full stop. Under the law by virtue of which the village authorities have been created, comma, on a query of the court, comma, nothing has been pointed out about the existence of any specific provision by which a village authority is required to maintain a truthful record of ownership of the land in question under their village. Full stop. 2000 Act. 2000 Land Management Land Act. It will be in volume 8, I think. Land Record Settlement Act. Land Record Settlement Act is which volume? 7.
2000.
Next para. However, it is noticed that as per the Arunachal Pradesh within bracket Land Settlement and Records bracket close Act, 2000, the state government is empowered to create revenue divisions and appoint revenue officers. Roman 2, chapter Roman 2. Full stop. Under chapter 3, there is a provision for title of lands, etc. So under the said chapter, the right of the government on trees, forests, etc. is also prescribed. Under chapter 4 of the said act, provisions for survey and settlement of land revenue is provided for. And under chapter 5, there are provisions for maintenance of land records, including preparation of field index and register of mutations. Full stop. Next para. From the facts as appears from this case, as there is no register of mutations has been produced by the petitioners, the court is compelled to draw a presumption that perhaps the state government is not implementing the provisions of the Arunachal Pradesh within bracket Land Settlement and Records bracket close Act, 2000. Full stop. In the absence of any official record of the ownership about the land in the state of Arunachal Pradesh, the court finds that there are hundreds of litigation in this court where people have filed writ petitions claiming their entitlement to certain plots of land wherever any development activity by the state has been initiated. Next para. Accordingly, in order to ascertain as to whether the state is implementing the Arunachal Pradesh within bracket Land Settlement and Records Act, 2000, the court is inclined to issue notice on the Chief Secretary to the Government of Arunachal Pradesh, as well as to the who is heading the Land Management Department? Secretary. The Secretary, Land Management Department, to apprise the court as to what measures are in place to identify the owners of land in the state of Arunachal Pradesh. Next para. The learned government additional senior government advocate shall accept shall transmit order of the downloaded copy of the order of this court to the Chief Secretary to the Government of Arunachal Pradesh, as well as to the Secretary, Land Management Department. Full stop. The notice to the Land Management Department can be routed through the standing counsel for the said department in this court. Next para. List after 4 weeks.
Lordship, meanwhile, this interim pray since page number 31.
What is the interim prayer?
Yes, interim pray. This tender chairman might open the tender and there might be some.
No development work. Section 28. Full stop. The next para, as the matter relates to development work, comma, by, what is it? And the right of the and the nature of prayer made would take care of the rights of the petitioners, comma, in view of the provisions of this for the specific relief act. Specific relief act. Section 20, capital A of the Specific Relief Act relating to provisions, special provisions for contract relating to infrastructure project, comma, interim prayer as made in this repetition is refused. Capital A that we are using.
Highly obliged, Lordship.
Lord, may I mention item number 5?
Yes.
Item number
Yes, you are
5, the item number 5, Darshan
item?
Singh versus State of AP.
क्या हुआ? What has happened to 5 and 6? Have you called that item? Some orders will pass. You are inquired later on from the court master. You're too late in appearing. You already passed some orders. I'm taking
Lord, may I know the date?
Please ask the court master after the court hours. I am not. I'll not be doing that service to you. Please inquire with the court master after the court hours. You'll get it notified in the order sheet. Just take a break and come back. I'll give you the 5 and 6 order of you. खबर कीजिएगा लॉयर को कर कीजिए उसको ये गलती मत कीजिए समझे संतोष जी ये गलती मत कीजिए क्योंकि जब मैटर उठा था आप बोले कि ऑर्डर हो गया है ये गलती मत कीजिए somebody was there online please wait can you contact the lawyer of the petitioner he was there online we thought that the order was passed please connect to him so that he can be online just let's we'll take it after some time वो भी है उसको मैं खबर दिलवा दूंगा
Lordship, kindly pass over the matter for a while.
okay next 11 to 16, Mr. Patin. Nobody is there, Mr. Patin's matter. 11, Lordship. Which item I won't remember?
11 to 14.
Yes.
16. Lordship, we have received the affidavit of land department today itself.
Okay.
I'm for the petition 11 to 14.
Okay. Both sides are represented. Mr. K. Saxena, counsel for the petitioner, submits that a copy of affidavit in opposition by the state has been received today. He prays for some time to go through it and take instructions. Mr. Matter stands adjourned today. List after vacation, list after the ensuing long vacation on the date to be fixed by the registry. All right. Yes, you got instructions? You got instructions?
My lord, there's no I have no instruction of such.
My lord, this under health, Mental Health Care Act 2017, my lord. There's an authority, my lord. The authority, the State Mental Health Authority.
No,
and the
no, you see, what is happening? The lady does have some problem,
Yes, my lord.
correct?
Yes, my lord.
But that is why I did not want to adjourn the matter,
My lord.
because apparently the prescriptions show that she has some disorders.
Yes, my lord.
Correct.
No.
So, but the problem is that under the act, there is a prohibition to accept mental illness
Yes, my lord.
unless it is certified by an authority. Therefore, for the court to even write in the order that he claims to be a
lord.
person with a mental disability
My lord.
is very difficult.
My lord. Under section 65, my lord, that any doctors like secretary, they have to get registered under authority, my lord.
We
That,
know
there,
that.
my lord.
We know that.
My lord, that,
That's why the problem, you see, this problem is genuine,
my lord.
but the petitioner is not correctly advised how to go about it.
My lord.
That is one part. But the difficulty of the court, we have told you, to mention in the order that the petitioner is suffering from some mental disorder is not permissible. There lies the problem. So, but we can still issue a notice, you
My lord,
convey
my
it to
lord.
them. Correct?
My lord.
Because
Remember, their prayer is only to consider the representation only.
that's
Their
why,
prayer.
that's why.
Only, my lord.
We are not saying in the order why.
My lord, my lord.
Correct.
Right.
Just convey it to them.
My lord.
Okay. Heard. Mr. M. Newell, and counsel for the petitioner. Also heard Mr. T. Tagam, the standing counsel for the health department. And for government, who will be there? You will be there? Yes. R. Basal, and the government advocate appearing for the state respondent number 1. Next paragraph. The petitioner is a serving medical officer who is in charge of THC, Chambang, CHAMBANG, and Yangte, YANGTE.
My lord is
My lord,
Chiputa.
now presently he is serving at Chiputa, PHC Chiputa.
PHC,
Chiputa.
how do you spell it? C?
CHIPUTA.
Okay.
Champang, he was earlier
Earlier
served
he was-
99 years.
You see, I am reading this
My lord,
synopsis. If it
synopsis
doesn't
is-
say there,
That is why.
I am writing what I am reading.
My lord. That should have been correctly projected in synopsis. That is because of synopsis problem.
And he has been transferred from, no, you transferred from where?
Chiputa to General Hospital Bomdila.
My lord, page
Page,
12
page.
is there, my lord. Transfer order, serial number 5,
From page,
12.
from PHC Chiputa, CHIPUTA,
To General Hospital
under
Bomdila.
DMO UPR to Government Hospital, Bomdila, under DMO West Kameng District by order dated 28/2024, which is assailed in this writ petition filed under Article 226 of the Constitution of India on the ground of health issues suffering by his wife and his mother-in-law. Full stop. It is projected that the petitioner has submitted a representation dated 26/8/2024, which has not been addressed. Next para. Accordingly, notice returnable in, give a fixed date, notice returnable on 23/10/2024 be issued. Or we can issue a shorter date.
My lord, their representation can be disposed of, my lord. This asking for disposal only, my lord.
How many days? How many days you want to take dispose of the representation?
My lord, 15 days, 20 days we can.
Hmm?
Let it be in separate side, within the 30 days we can. dispose.
My lord, as per the instruction,
You make it within 15 days, you did departmentally.
new
My lord,
representation has been already submitted.
My lord, their representation, they, instead of submitting the commission, they have submitted the director. I talked to the director, my lord, since it has been submitted to the director, competent authority to consider the grievances is the commissioner, my lord. Now this,
So he has given it to Commissioner,
yes, my lord, recently, my lord,
29, okay.
my lord.
Okay, representation dates have not been addressed. Representation dated 26/8/22 to the Director, Health and Family Welfare Department. First of the Learned Counsel for the petitioner submits that on 29/2024, another representation has been submitted before the Commissioner, Department of Health and Family Welfare. Next paragraph. Issue notice returnable in 4 weeks. Give a date after 4 weeks. 29/10/2024. Make it 30/10/2024. Requisite extra copies of the repression be served on the learned Departmental Council and the learned State and Department Council in course of the day. Next para. The pendency of the writ petition shall not be a bar for the Commissioner, Department of Health and Family Welfare to dispose of the representation dated 29/2024 submitted by the petitioner after considering the medical documents appended thereto. Next paragraph, based on just before that you write the said representation may be disposed of within period of 2 weeks from 15 days from today. Post of next para as an interim measure and interim measure, till the disposal of the representation dated 29/2024 by the Commissioner, Health and Family Welfare Department, no coercive steps shall be taken against the petitioner.
Deeply obliged.
Obliged.
Item number 5 and 6.
Council is joined. Connected? Yes, I am sorry, I did not know. This matter was, no order was passed. I am extremely sorry. Yes, item 5 and 6.
My lord, here, my lord, in item number 6, my lord, in the morning, I have filed affidavit in opposition, my lord, for 2 and 5, my lord. May I pray this be taken up tomorrow, my lord?
You have filed an affidavit. You have served it to the
My
counsel
lord.
for the petitioner.
Yes, my lord. I have served through the WhatsApp, my lord.
Okay.
Copy, my lord.
You have got the copy of affidavit?
I am in item number 5, my lord.
Yes, yes. Item 6 and affidavit is filed. You have got the copy through your local counsel?
My lord, I also have received.
I'm not getting your voice correctly. Please repeat again. Item 6, affidavit in opposition is
We have
filed.
received a copy today, my lord. I'm not sure this is the same affidavit.
Okay.
I can confirm, my.
Okay. So we adjourn the matter? We adjourn the matter today?
Yes, my lord. Any Monday may be fixed, my lord.
Okay. When do you want?
Any Monday, my lord.
Huh?
If my lord is giving in the month of October,
Yes, it will go to October after 30. You have to take a date after 28.
my lord, in November, my lord, first week or second week, whatever suits calendar of my this honorable court, my lord.
Okay. You give it on 4th November? Well. Just in item 5, what has happened? Item 5?
Item, my lord, what happened in item 5, my lord, the issue is, my lord, no release of pension, my lord. That we have already released, my lord.
You have released?
My lord. Now, in between, the complainant authority.
The counsel for the respondent says that you have received the pension. Is it right?
My lord,
Mr.
I
Pandey?
have received some amount, my lord. The workout of which he has to give me, my lord. We do not know what on account of what under what head what has been given to us. So
Yes,
that's why
well-
I prayed, my lord.
True that, my lord, what happened in this case, my lord? Earlier, he has dismissed from service, my lord. Now, court interfere, my lord. He has given compulsory retirement, my lord. Now,
Yes.
competent authority decided to give him a two-third pension, my lord, in term of, my lord, rule, my lord, every rule, my lord. Now, that, in issue item number 5, my lord, at that point of time, his pension was not released, my lord. Now, that has been released, my lord. That order, my lord, this,
This two-third is done under which provision?
under CCS 40, my lord.
Under?
CCS 40, my lord. Under, my lord, rule 41 of CCS pension rule 1972.
Rule
my lord.
41 CCS pension rules. For that, you have to put him to notice, I think.
My lord, yes, my lord, commission advice of, my lord, APSCC, my lord, that needs to be taken, by. Now, that order they have challenged in item number 6, my lord.
Okay, reduction of pension is challenged in item number 6.
6, my lord, that we have filed with them.
Okay. CCS pension rules 40.
Rule 40, clause 1, my lord.
41.
Rule CCS pension rule 1972, my lord. One, my lord, copy I have, my lord, print out, Xerox copy.
He was compulsory retired. Where is the order?
Order, my lord, will in read petition, my lord, at page number 35, my lord. Page number 35, my lord. Annexure number C, my lord.
Okay, you're giving a calculation to the petitioner.
My lord.
Even if you're giving 2/3, you give the calculation to the petitioner. How many days you want?
Pardon, my lord.
The calculation of that 2/3, however you have arrived at,
My lord.
please give it to the petitioner.
That we have given, my lord. I have bring on record, my lord, in
No, the
evidence file
counsel-
today, my lord.
You see, the counsel of the petitioner is here. He says that it's not been received. You said that it is received. It is given. Where is the document?
That I bring on all those on record, my lord. On today, in everyday opposition, my lord. Today I have bring on record, my lord. I have bring on five.
Shows the copy.
Starting from my lord, connection number A to my lord, G, my lord, is the all the benefit, my lord, that given to him.
Page.
Yes, in my lord, this is a different, my lord. Is connection number A, my lord.
No, you see in this annexure A,
My lord.
you are only giving that an amount of rupees 3,17,162.
No, my lord.
Now, how does one know that what is the 3,17,162?
My lord, it, my lord, take up this, that is my lord, area pay, my lord, area pay, my lord.
No, one by one. We are this the first page you showed us in annexure A is 3,17,162 for area pay.
Yes, my lord.
Correct.
Yes, my lord.
Now, area pay order is at page 1. This you are showing us. Same
Second
thing. Where is the calculation? You see, can I explain it in a better way? Since I'm giving, I'm good in giving horrible examples. Now you see, you charge your client fees of X rupees, and then you say that you also charge clerkage 10%. Correct? So if you give a consolidated bill for Y amount, it will not happen. Then nothing will happen because you'll have to bifurcate your bill to disclose the fees charged and the component of clerkage. Correct? Only then the client will know how much you are charging. So with that example, I'm trying to make you understand that if you say 3,17,000, what would somebody understand?
If some calculation, my lord will find it.
Give a calculation. This is not happening. Some person is retired. Pension is his property. He must know what property is getting.
If my lord turn to other next page, my lord, some calculation is there, my lord. This is in regard to my lord, his leave encasement, my lord, page number 2, my lord. This is leave.
This is 2 lakh retirement gratuity is 2,33,000. What is the calculation?
It 2, my lord, this is a
period of 7 years.
Leave encasement, my lord.
I'm sorry, I'm not able to get it. Two lakh 33 is okay, but how is 2,33,000 arrived at? Somebody has to understand that. Give him a calculation sheet. Look, in this item 5, you write separate order. Mr. J.S. Pandey, counsel for the petitioner, as well as Mr. L. Parmel, standing counsel for the which department?
I am on 2 and 5, my lord.
2 and 5. One, Mrs. G.A.T. then additional senior government advocate for respondent number 1, 3, and 4. Next paragraph. The learned counsel for the respondent numbers 2 and
5.
2 and 5 submits that the petitioner has been paid his arrear salary, gratuity, as well as pension. Next paragraph, the learned counsel for the petitioner has submitted that although the petitioner has received some money, but he is not aware of the calculation as to how this figure has been arrived at. Next paragraph, accordingly, the this breakup will be given by whom? It will be by your department or it will be by the Directorate of Audit and Pension? Who will give the breakup of figures?
Payment, my lord, we will make, my lord. Calculation for
You make it. So it will be Commissioner Power.
Power, my lord.
We direct the Commissioner within bracket Power to through his concerned officer to provide the petitioner about the breakup of the calculation of pension and other retirement benefits which has been remitted to the petitioner. Next paragraph, list on.
My lord, 11th or 18th November, my lord, if possible, my lord.
4th November.
11th or 18th, my lord, not on 4th month. I'm requesting. 11th or 18th.
Okay, 18 November 2024.
Highly obliged, my lord.
In second item, you say that Mr. S. Pandey, counsel for the petitioner. Mrs. G.A.T., government advocate appearing for respondent numbers. One, 3, and 4, and Mr. L. Parme, learned standing counsel for the respondent numbers. Here you are. 2 and 5. 2 and 5. Next paragraph. The learned counsel for respondent number 2 and 5 has submitted that affidavit in opposition has been filed. Post of the learned counsel for the petitioner seeks some time to go through it and take appropriate instructions. Post of matter stands adjourned today. List on same date, 18/11. Okay.
Highly obliged, my
lord. Obliged.
This. Yes, Mr. Pani.
The only thing the petitioner is praying for at this stage is that the deed be completed, my lord, within that prescribed time period. so that my lord, I can apply for BRS. I earlier made an
Yeah.
attempt for resigning,
The DP is instituted when?
my lord, that was on 2nd of August 2023. Earlier in the 2014, my lord, I submitted my resignation while I was working as a constable. There is also will find it page 27. I'm just pointing out the facts, my lord.
Just a moment. Yes, you're appearing for the respondents?
Yes.
In the meantime,
You're giving us a very stale news.
they promoted me also in the meantime.
He has submitted his representation to.
No, you see, then if Mr. Panging has been promoted, then there's nothing in that DP. We have to close that DP.
No, because before filing this
You know the
resignation.
law.
Yes, Your Lordship. But
There are many judicial pronouncements by this court as well as by the Supreme Court.
Lordship.
What happens in the case during the pendency of a DP, somebody is promoted? Everything is washed away.
No, my lord, promotion
The-
was not during the pendency.
not during the pendency of the TCE. Yeah.
Not during the pendency of the department.
Okay. Or before that,
No, after. Promotion was before the D.
before the DP. Oh, so
Yes.
that changes the situation.
Yes.
Okay.
Actually, I submitted the resignation way back in 2014. They forwarded it to the competent authority. No decision was taken. They stopped deploying me in duty also. In the meantime, they promoted me. Thereafter, the petitioner, my lord, after the promotion came, he submitted the representation saying, you are not even deploying me, my resignation also not been accepted. Then they woke up, then they suspended me and all. All I want now is the DGP completed, my lord, in terms of Premnath Bali, my lord. They are supposed to do it at least within a period of 1 year. They have not done it. My instructions are that he wants to go on VRS now, he's qualified for VRS. This is the situation the petitioner finds himself in. Memorandum of charges at page 46. man.
Okay. Mr. D. Panging, counsel for the petitioner. And Ms. R. Basar and government advocate are present. Next para. The learned counsel for the petitioner has submitted that the petitioner had submitted his resignation in the year 2014. And thereafter, although the resignation was not accepted, but the petitioner was not given any active duty. Full stop. Thereafter,
Thereafter, my lord, after I was promoted on 10/6/2022.
however, in the meantime, the petitioner was promoted on
10/6/2022.
10/6/2022
To the post of head constable.
to the post of head constable.
Thereafter, my lord,
Thereafter, the petitioner approached the authorities that he is not been given any active duty. Full stop. On such representation, the petitioner was suspended.
Yes.
And departmental proceeding was drawn up. Full stop. Accordingly, at this stage, the learned counsel for the petitioner has submitted that he is instructed to press the prayer that the departmental proceeding should be completed within a time frame. Full stop. Next para, on a perusal of the affidavit in opposition filed by the respondent number 6. It appears that a stand has been taken that the police personnel were deployed for election duty, for which the result of the departmental inquiry could not be held in time. And it is projected that reappointment of an inquiry officer is under process. Full stop. The affidavit in opposition is filed on 19/7/2024. Full stop. Therefore, it appears that for last 6 months, no steps has been taken for the departmental proceedings to continue. Full stop. Next paragraph. In terms, in light of the prayer made by the learned counsel for the petitioner, the court is inclined to grant 3 months time from the 3 months time to conclude the departmental proceedings initiated against the petitioner from the date on which a certified copy of this order is furnished to
Superintendent of Police, West Cameng District. Superintendent of Police, West Cameng
to
District.
the Superintendent of Police, West Cameng District, Arunachal Pradesh. Next para, it is needless to say that on resumption of the departmental proceedings, the petitioner shall cooperate with the inquiries so that a time-bound disposal can be achieved. Next para. List after 4 weeks. Weeks, by which time just say it like this. On the next date of listing, the learned government advocate shall inform the court as to the progress of the departmental inquiry and of the status report of the inquiry. Next para, list after 4 weeks. Resume after lunch. Yes.
I'm sorry, my lord, I could not find a color printer, my lord.
No, it's okay.
Within the court premises.
It's okay.
This has stopped since the notice, man.
Okay.
In fact, in our appeal also, we have mentioned that we have approached the department also, but no steps were taken.
Okay. Mr. D. Sokil, learned counsel for the petitioner, as well as Mr. I.D. Ram, learned. Huh? Oh, and no, so I'm sorry, extremely sorry. Learned
1 to 3.
Government advocate appearing for Respondent, both the respondents,
Yes.
both the respondents. Next one. The petitioner contends that is allotted quarter was in a dilapidated condition and not and unsafe, and therefore he started a construction of a building in place of the quarter. Full stop. The petitioner is presently working as a technical assistant under the DRDA. Full stop. Accordingly, on 21/8/2024, a notice was issued to the petitioner under Arunachal Pradesh within bracket eviction of unauthorized occupants bracket close Act, to 2003. Full stop. In connection with the said proceedings, by an order dated 12/9/2024, the estate officer issued a direction upon the petitioner to remove the construction within 15 days. Where is that order? 12/9.
12/9 is page 25, madam.
Okay.
And type copy is page 26, madam.
Full stop. Agreed by the said order, the petitioner has filed a statutory appeal before the Deputy Commissioner, Upper Subansiri District, Dapurijo. Full stop. The petitioner, the learned counsel for the petitioner submits that as per his instructions, the Deputy Commissioner has refused to take up the appeal and the matter has been referred back to the estate officer.
At page 28, if my lord will see down below, my lord.
Which appears from note. No, not is it that in this regard, the learned counsel for the petitioner has referred to the note appended to the memo, the petition for appeal within bracket annexure 4, page 28. So where is that act? Unauthorized occupant, which is in which book?
Volume 8, my lord.
Volume
8, AP
Eight.
volume 8. Page 160.
Page
160.
160. Which provision? Section?
Section my lord, 12 is the appeal, my lord.
What is it?
At page 169, my lord.
Next one. Next one, as it appears from the provision of section 12 of the Arunachal Pradesh public premises within bracket eviction of unauthorized occupants bracket closing Act, 2003 provides for an appeal which shall be before the Deputy Commissioner of the concerned district. Next, the court is, sorry, the comma, the court is inclined to issue a notice returnable in how much time?
Within 2 weeks.
Returnable, 2 weeks will be vacation. It should go after vacation. Returnable on 30/10/2024. Make it 28/10/2024. Oh, sorry. Requisite extra copies of the reparation be served on the learned government advocate in course of the day. Next paragraph. The pendency of this repetition shall not be a bar for the Deputy Commissioner, Upper Subansiri District, Daporizio, within bracket, respondent number 2, sorry, respondent number 2, to examine the provision of section 12 of the same Himachal Pradesh Municipal Act and do the needful as he may be so advised. Next paragraph. The you see, on a direction of the court, the learned counsel for the petitioner has obtained 2 photographs of the construction site. Post of. He said the printout of the said 2 photographs are made a part of record. Post of. The taking note of the nature of construction carried out so far. The court is inclined to prohibit the petitioner from proceeding with any further construction. Full stop. Next slide. As an interim measure, it is also provided that till an appropriate order is passed by the Deputy Commissioner, Upper Subansiri District, Daporizio, in connection with appeal filed by the petitioner on 17/9/2024 within bracket Annex 4, the additional Deputy Commissioner, Estate Officer, Upper Subansiri District within bracket respondent number 3 shall maintain the status quo with regard to the position of the petitioner over the quarter in question. Next paragraph, it is clarified that in the event the petitioner resumes construction without the leave of the court, this interim order would stand lapsed and vacated without any reference to the court. Next paragraph, list on What date did we give?
My lord.
Notice returnable on
Yes, my lord.
28/10. So we have prohibited you from making construction.
My lord.
And if the construction is carried out, then your order will lapse.
My lord.
And till then, your protection, till the disposal of the appeal, your position is protected. Yes. Yes. How do you claim, on what basis
My
you
lord,
claim that you
I
are the
think
genuine landowner?
I'm sorry.
Yeah, on what basis you claim that you are the
Yes.
genuine landowner?
Yes, and now, my lord, there are two things. One is that, my lord, this is a community land actually. This is community land, number one. Number two, because last time I have been told that your lordship want to know, to see the earlier writ petition which has been filed, 50 of 2021. 50 of 2021. Lordship want to see that writ petition, 50 of 2021. Why? Because, my lord, I have seen the recording and that's now advantage for us, what your lordship really wanted. Because the matter, my lord, before looking into it, what is the matter about why your lordship has asked that? In 2010, under section 4 of 1894 Act, the requiring authority, the army wanted certain land. And the acquiring authority is the government, land belongs to them. So notice was issued under section 4 of 1894 Act. And there was also a notice which is given 30 days notice to file objection. Accordingly, some of the beneficiary of my learned friends client along with us, which belong to us, a clan, they file objection before the government, before the deputy commissioner. We also file objection, it is on record. 2010, we represented on the basis of the objection 30 days. Now, your lordship has not been, even in spite of those events, it has not been decided. In the meantime, 2012, there were a list of beneficiary, 26 number of beneficiary, which was prepared by the deputy commissioner, which our name was not included. In the meantime, the government decided to abandon that 2010, that notification of 4 under section 4 of 1894. And they came up with a new notification under section 10 of the Balipara Act in 2014. There also they said, now what I have seen, the description of the land they wanted more than what was there in 2010 notification. Now that was under section 10 of the Balipara and Tirap Act. There also the 30 days time was given. Accordingly, on the basis of 30 days time, we also file objection before the authority. Now the authority, my lord, doesn't decide our representation, which was filed, not on the basis of the earlier, on the basis of 2014 notification, till 2020, we have given up. But from 2010 till 2020, there was no award which was prepared. Only the bill, assessment, rough estimate was prepared by the government, because 2019, in the meantime, certain list of beneficiary was not there. 2019, certain new list was included by the deputy commissioner. 2021, 50 of 2021, a writ petition was filed by us. In that writ petition, a query was put forward by the court that whether that 2014 notification was brought notice to the court or not. Now, I have gone through that entire writ petition. 2014 was brought notice to the court. It was annexed. 2010 also, it was brought notice to the court. Ultimately, court passed an order. This court passed an order that there is an objection which has been filed. Repetition has been filed on the basis of 2014. And till 2020, those repetition has been filed. So you please dispose and consider in accordance with law. That was the order that was passed. Now, my lord, we represent the matter. We say this is a High Court's order. They were not doing anything. Ultimately, contempt was filed. When the notice was issued, now that thereafter they have issued a notice that yes, a date has been fixed, all us, then a hearing will take place. Accordingly, hearing was taken place by the Deputy Commissioner. Now, Deputy Commissioner passed an order. Against that, we are before this court. Now, what is the order that has been passed by Deputy Commissioner? Is this an order in consonance with the court's order? My lord, I have checked the order of the Deputy Commissioner, which I agree. The finding of the Deputy Commissioner is not based on 2014 notification. 2010 abandoned notification, which decides, he said that yes, there are representation in 2010. 2011, you represented the matter. We have examined, and on the basis of 2010 notification, hearing has been concluded, so you are not entitled. That's the reason why we are before this honorable court. Number two, your lordship has asked a very pertinent question. I have seen that how a read court will decide. That's your lordship is asking, very pertinent. We are not there to say who will be included. We can't give the list that your name should be included. You have to go before an appropriate civil court. If your list has not been included, if you're really aggrieved that your name has not been included in the list.
No, civil court will not entertain.
No, that's
But
what.
there must be an adjudication with regard to title.
No,
That
no.
is normally under the Land Acquisition Act.
Yes.
And Land Acquisition Act will have a provision which says that the civil court jurisdiction is barred.
Yes.
But the
No.
deputy commissioner, when they acquire, it is in the objections that they will have to settle. And that
Now,
is-
now my whole case here, why we have come before this honorable court. If your lordship looks into 50 of 2021, your lordship want to look into that writ petition. That writ petition is based on my representation which has been filed after 2014 notification.
That's fine.
Now that has not been disposed of in terms what the court has passed an order.
That's-
Kindly look into 50 my lord. Kindly see 50 minutes.
Because if 2014 was represented, then they would have to take into cognizance the 2014 notification.
That's not been done. So I don't want that your lordship will decide. That's what they should dispose of. If you are not entitled, we will not entitle, man.
Which is that 2014?
Yes, my lord, at page 28.
28.
Page 28 of 50 of, that's earlier repetition of 2021. 50? No,
Yes, 50.
50 of 2021.
Ah.
Earlier repetition.
Yes, page number?
See page 28. 26th of February 2014.
Yes.
Also got it?
Yes.
Yes. Kindly see. My lord, at page 19, the earlier notification of 2010, which was brought notice to the court, both the note, page 19. Page 19.
Yes.
Also got it?
Yes.
Yes, there are now after 26th of February 2014, my lord will kindly see at page 35. Page 35. This is 19/10/2020. Next 37 is
Just-
4/8/2020.
Just a moment.
40 is 13/7/2020.
Oh, but this page 28,
Yes,
this has a clause of 45 days.
I'm sorry. No,
From-
we have done there are before that also, which is a part. Yes. In the present writ petition also we have annexed here. In the present writ petition. Kindly see that, my lord, present writ petition. My lord will look into the present writ petition.
Because if it is not within 45 days.
No,
there is
then
a
of course,
Supreme
my
Court-
lord.
Supreme Court judgment
100%.
is there.
No, your lordship is right. I'll see from the start. Kindly see, my lord.
Page.
Notification of 2014. No, we will not show that. Notification of 2014 is at page 67. 67. My lord, this see kindly 67. The read petition.
67.
67 of the new read petition.
Yes, it is there.
26 of February 2014.
Yes.
Now, that's your lordship objection is at page 71. Within 30 days, 12/3/2014, at page 71.
Okay. Yes, and the disposal order, where is that?
I'm sorry.
Disposal order of the deputy
Yes.
commissioner, where is that?
Yes, disposal order is at page 133 is the order. Disposal order. 19/5/2022. Lordship, kindly see at 138. 138. And I will bring notice to one thing, my lord. This another writ petition was filed. I think I don't know whether I have checked everything. I checked details. 153. One writ petition 153 of 2013 was filed by the list of beneficiaries before the High Court in the learned single judge. 26 number of beneficiaries has come. And they said that what you are doing it, final assessment is only you are preparing it, no award has been passed. So the court said that you have to immediately an award has to be prepared. Against that, Union of India has gone for a division bench. In the division, I have got that order. In the division bench, specific stand of Union of India is that 2010 has been abandoned. So we are coming with 2014. Any decision taken by 2010 has to go. There's specific abandonment, and there is an order I will show you. Now, Deputy Commissioner decides at page 138, kindly see.
Yes.
138, last paragraph, after hearing both the petitioners, respondent beneficiaries, and going through the records of land acquisition, following observation have been made a decision taken. As it was made aware during the hearing proceeding, availability of records available in the office file and land acquisition process was done a very transparent, impartial as per provision of Land Acquisition Act 1894. Sufficient time period was given to the claim and objection by government notification, preliminary notification dated 5/6/2010 of the Commissioner Land Management, Itanagar, memo number so and so. Now 139. Hearing were conducted as per provision of section 5A of LA Act 1894 on dated 7/3/2011 at Shivaji Nagar, on dated 3/8/2011. So and so. Matter of ownership has already been disposed of by DC in the year 2011. Hence, no beneficiary under other than 26 enlisted beneficiary admitted.
I got it.
And the order passed by the High Court. Kindly look into it. Please see the order that has been passed by the court. The order that has been passed by the court was at page 93. It starts. 93 at page 102. 102. That is 50/2021 order.
This order is dated?
Dated is 24/2/2021 by the High Court at page 101. And see 102. Page 102 at paragraph 4. Paragraph 4. Having regard to the grievance projected by the petitioner and limited prayers so made this petition dispose of by directing Deputy Commissioner Lohit District Tezpur respond dispose of representation of the petition, last one being submitted on 13/7/2020 by taking into concern all relevant factors and projected petitioner and thereafter pass a reason and speaking order. Deputy Commissioner gave due opportunity so and so within 2 months. Now see the order, my lord, it is of 2011. So that's what we are agreed with. I think we should also will not go into other aspect of the matter. Only look into this aspect.
Yes.
And moreover, my lord, I think it has to be projected. No award has been passed. No award. It is only assessment they are making.
Okay. Yes. We'll address this.
And for the Deputy Commissioner, we had filed our affidavit here. In our affidavit also, we have said that this is a repeated litigation losses. And then losses,
Affidavit.
Page 11, my page 11.
Page 11.
Affidavit by respondent number
Oh,
4, yes.
yes, page number.
One, before my learned friend proceeds, we have not filed any reply to this because they have filed recently this reply.
Okay.
That's why I'm just informing on which.
Yes.
Yes. Lordship. Here, Lordship will see the petition.
Paragraph, please. Paragraph
Lordship, paragraph 17,
17. Yes.
page 11. Here, Lordship, the petitioner in the incident case has already filed WPC so and so, which has already have been disposed of by the Honorable Court with a direction to the respondent number 4 in the present writ petition to dispose of the matter. The respondent has already disposed of the matter on the merit of the case and records available in the office. The petitioners also filed the matter before the Honorable Governor on AP, Lordship. Further, the matter has been taken up by SIC by so and so.
No, but you are in a very, very difficult position.
Lordship,
You are in a very, very difficult position.
no, Lordship.
You see, there is a gazette notification
Yes, sir.
under Badipara Act
Yes.
and this affidavit. Amongst two, you'll have to choose one.
Lordship,
There are two things. One is the 2014, that notification under Badipara Act.
Lordship,
Now, as a government advocate, you will have to choose one between the two. You accept the notification or you accept this affidavit. Two things can't stand together.
I'm sorry to trouble my lordship, friend. Please see their affidavit at
No,
this.
it's okay. The letter complete. We'll come back to you.
Yes, 36, it is clear by division bench.
Because you see, there is a notification. Mr. Das has shown as notification.
yes, Lordship.
Now, if we accept your submission with regard to Deputy Commissioner, what happens to that notification? Can we wish it away? Can we say it does not exist?
Lordship, this is only said that.
That's why I'm saying you are in a very, very difficult
we have
position.
had the Lordship.
You sit down, you
Petitioners.
take a decision and tell us. Think over for 5 minutes and tell us. There's a notification. Which page was that notification?
That notification. Yes, 14 notification at
Where
page
is-
67
67.
of our writ petition,
67.
of our writ.
So your very good friend and neighbor, Mr. Kamduk is there to assist you. Now tell, what do you choose? You sit down, you better consult.
Yes.
My lord, once again, if you all also give me, permit me, see page 36 of their affidavit, 35 of their affidavit. 35. That will clinch the entire matter of the affidavit filed by government. Response number 4, which my learned friend was just
35.
page 35,
That's a judgment of
division bench.
division bench.
See now, my lord, at paragraph 5, at page 37,
Paragraph 5.
page 37. And the provision of law has been lapsed. Therefore, the implement issued by learned cannot be implemented at this distance point of time. Mr. Pathak has further contended a plot of land, not a private land. Same is a government land. Allotted to Army for SM base under this payment of respondents so and so does not arise in my outlook. Because they calculate on the basis of the 2010 list of beneficiary. So 153, all those list of beneficiary came to the court and they said that we are entitled. Why they are not? That when Division Bench Union of India went and they said, how can we calculate on the basis of 2010 list of beneficiary? That is the observation of the Union of India themselves was stating at page 35. At paragraph 5. That's their own statement. And why the division bench said, yes, it cannot be implemented. And they prepared a list of beneficiary of 2000 on the basis of 2010 notification.
Let us sit down and take a choice of stand. Yes, Mr. Kato.
I'm very sorry, my lord, before my lord, assumptions made by the my lord, that is the council, I could take made, the, well, since, your lordship wanted to see the, my lord, the presentation of 150, my lord, this for the. But here I am appearing on behalf of private respondent number 5287, private respondent beneficiary. And the subsequently, by amendment, my lord, the petitioner says, the implemented respondent number 28 to 30, Union of India. So therefore, my lord, the Union of India is one part, my lord, and I am appearing on, since I am already appear in, behalf of the private respondent number 5227. My lord, I will continue to appear on behalf of the said respondent. This Bishop then has.
For union, then who will be appearing?
I've already intimated to the Union of India, the Indian Army, but this piece of land has long history, man. It started in the year 1962, and thereafter, my lord, the 1962 from again, my lord, the 1982, my lord, we are time and again praying for the, my lord, the payment of the compensation. And the several.
No, but you see, Mr. Kato, if I have understood Mr. Das correctly, then it means that everything will now start from 2014 notification. So past history is wiped off. Now you'll have to adjudicate whatever is available on the basis of an objection raised post 2014. There may be a background which will definitely be a part of 2014 representation.
But
if I have understood him correctly, then the clock will start from 2014.
My lord. Exactly,
Antiquity is or a history is something which you can plead in that 2014 representation, but we'll have to start from there.
My lord, what I wanted to make submission is, my lord, they were also the, my lord, the resident of this place, my lord, and they were fully aware of the, my lord, the proceedings, my lord. It started in the year 1982. Time and again, we are making representation before the authorities concerned, my lord. Of late, my lord, in the year 2008, my lord, this was finalized. And thereafter, because of the non-payments of the compensations on the part of the Union of India, my lord, the original landowner, my lord, 26 in number, my lord, moved this honorable court by way of, my lord, the writ petition number 153, my lord. In the 153, my lord, that direction was given to the authorities concerned to, my lord, determine the, my lord, the rates and, my lord, the amount, my lord. Thereafter, my lord, against that, my lord, the order, my lord, the Union of India, my lord.
You see, there is one difficulty.
My lord.
I'll tell you what. You see, if you are referring to an old acquisition of 1968 or something, then ideally what happens is that the claims and objections would have been under the old act. Correct?
Madam.
But all these claims and objections cannot stand when 2014 notification has come up. You see, you may be 100% right when you claim that you were the only claimants. But the fact is that somebody makes an application now under the 2014 notification claiming their right. So can you say that in 1968 the objection was not there and therefore their objection shall not be considered now? Because the act does not say so. There are only people who have established antiquity rights can only apply. So once there is an application, the district deputy commissioner should have taken into consideration the new notification and should have gone ahead. Number two, if you say that no, the deputy commissioner should not take into consideration 2014, then your right under the 2014 Act goes away. You go back to Land Acquisition Act. Even you can't take benefit. You can't, even if there's an award, you can't have the award of any other claimants but those against whom the notification was issued. Definitely, today you don't want that. The problem would be that if it is under the old act, then the under 1894 Act, again there are certain provisions which will apply, that if the land has to be taken over, resumed, and then there's a section 12 which prescribes that the payment should be made first. Correct. Then your claim for money would stand barred by limitation. You can't say now that it is a continuing wrong. Your land has been parted away. From that, the limitation will start.
Very facts of the case is, after the order passed by the Honorable Division Bench, the press notification was initiated. That is the.
That's why.
In the press notification, claims and objections were invited.
If you admit that there is a fresh fresh notification, now please tell us what would be the date within which the objection has to be filed. 45 days from the date of notification under the Balipara Act. Right? Is it 45? Objection, claims and objections, how many days? 45.
45.
So it's 45 days. So from the date of notification, 45 days, whether Mr. Das has appeared within 45 days or not. If he has appeared, please tell us how the district commissioner will say, or the deputy commissioner will say that no, I have claims and objections were adjudicated under 2010 Act. Now, if you admit 2010, tell us. If you admit 2014, tell us. Because for you also, the consideration will be different.
The reference has been drawn as per the early round of the objection.
Whatever be it. But you see-
Exactly, determination was done in the year after
No, but
press notification
that's why I'm
issued by
putting the
the
question.
So the ownership cannot even change by the lapse of this the proceeding.
No, but the
The ownership
compensation
remains the
component-
same.
But the compensation components would change. Because
Therefore,
now-
may I take your lordships to the.
Because now in 2024, you will not be able to establish what Jirat was available then.
Just for a moment, may I take your
I'll
lordship to
tell you
the.
very simple that you cannot show from 68 till now that the Zirat which was there would still be alive or worth paying any compensation.
Just for the clarity, may I take your lordships to again the or impugn order passed by the deputy commissioner, wherein detailed discussion has been made.
Before that, please tell, you admit 2010 or 2014. Let us take the stand of private respondents first. You stand on 2010 notification or 2014 notification?
Admittedly, the press notification,
Then-
14.
Then how do you sustain that order? 2000, the deputy commissioner's order.
That's because this has been issued in the compliance with the order passed by reasonable court.
No. You see, let us say the High Court gives a direction. I am always giving a very horrible example. High Court gives a direction, you determine the compensation. And the man says that, okay, I don't determine the compensation, but his claim is false, therefore I order his arrest and detention. Now, can you say that this order is in compliance with the High Court order? Did the High Court say that you base your judgment on a repealed notification? Did the High Court say that? That 2014 we take cognizance, but you dispose of under 2010 Act.
So, in that case, may I pray the I may be allowed to come with the affidavit, So, therefore, this was my submission. This could have been my first submission.
You should have been your first submission. After you see, now we are. No. Look at the time. Now we are where?
Admittedly, I just informed the senior counsel that today I'll take time for
He tried. First he was trying. Now,
No, just
when he
declare-
got there, now he said.
This
Try,
very
try.
morning, I informed the
Try,
senior
try.
counsel.
If you don't succeed, try another way.
Malad, therefore, Malad, since Lordship has wanted to see the Malad, the writ petition number 50, Malad, disposed of Malad. Otherwise, I could have made the Malad that submission, Malad.
Because Mr. Kato,
Malad.
I don't know why, but my life when I was there comes back when I put questions. The art of cross-examination comes live. I can put questions and then trap you.
Malad, admittedly, without having Malad, my pleaded Malad, in the affidavit, Malad, I'm not in a position to Malad, put the Malad, the things, Malad. So therefore, Malad, a week time may be granted, Malad.
Initially, when I was to be elevated, my anxiety was that I knew nothing but only CPC.
Malad.
That was the biggest disadvantage I had.
Since,
But now it turns that
Malad, since everything is on record, Malad, this will not change the facts, Malad. However, Malad,
it's an advantage to
at
know
least
civil procedures.
8 week time ever since Malad, and I've also communicated.
Even I'm telling to the young members in the bar who are sitting here, devote some time in reading the civil procedure code or criminal procedure code, whatever your interests are. But even for writ petitions, knowledge of CPC would be required. And this is very essential, so far as my view is concerned. I may be wrong, but still that is my view. So you pray for an adjournment. Yes, Ms. Ete? Between the two devils, whom do you choose?
Lordship, and my bandit friend have said, Lordship, we'll need some time. And take instruction, more instructions.
In the meantime, but there,
Okay.
Malad, other respondents, the instruction will also come. And respondent number 28, 29, and 30, Malad, newly implemented, Malad, Union of India.
Notice has been issued to them.
Yes, Malad.
Notice is served.
Well, I'm sorry, the police.
Malad, I'm sorry, Malad,
Which has not been included?
newly implemented respondent number 28, 29, and 30.
Which one?
Union of India.
Oh, Union of India. Yes, we have.
Earlier,
28, 29, 30, I'm not sure.
I'm sorry, Malad.
Has the notice is served?
Malad, it was on 5th February 2024. Steps happen order from
Fifth?
5th February, Malad. 0502 2024.
There is the implement order at page 154.
IA.
Order of the court. Yes,
IA.
yes, IA.
Who
It has to be-
filed the application?
I'm sorry.
Who filed the application?
Petitioner.
We filed.
You filed.
Yes, for impleting them. And that has been impleted at page 154, kindly see. Of our order. is-
28, 29, 30,
Yes,
the order of 9/4/24 says, Mr. S. Mo, Learned Counsel for the Learned Counsel is permitted to serve notice to respondent numbers 28, 29, and 30 through the Learned DSGI
yes.
in course of the day. Now, what is done? After that, 21/5, notice is deemed to be duly served.
Have we served?
Who is
Yes.
DSGI?
We
Who
have
is
served and we have amended also. That is why this
Okay,
amended.
so DSGI will have to appear.
Malad.
As government, somebody will have to appear.
Union of India.
Union of India, Malad, I have intimated to the
They have
Malad.
appeared. Who appeared?
No, Malad.
Each junior has appeared.
Okay,
Yes. CGC, Malad.
okay. So he's absent today?
Today he is not.
No, if somebody is not there, then the right to file counter will not be there. Somebody will have to pray.
My learned friend,
That part, Malad.
well, he should not pray for both.
That's
no,
why,
Otherwise,
Malad,
I'll
as I already pointed out.
no, that's why somebody must make a prayer, otherwise that
My-
right goes. You ask your colleague to be here. Follow him.
Malad, I'm informed Malad is owing to his Malad, the health issue, Malad, he is not available in the station.
Okay. Okay. You want to file a counter here?
Where, my lord?
Affidavit in reply?
Yes, we'll file.
Okay. Mr. D. Das, Learned, Senior Counsel. assisted by Mr. K. Mohammed, counsel for the petitioners.
S form is there. Next form.
Mo.
Yes.
Okay, S.
Both-
Mo. Counsel for the petitioners. Pray for, and is granted time to file affidavit in reply against affidavit in opposition filed by
Respondent number 4.
respondent number 4. Mr. M. Kato, the counsel appearing for respondent numbers
5 to 27.
5 to 23. Also prays for some time to file affidavit in opposition in the matter. So there is no representation from the respondent numbers 28, 29, and 30. Next para. The learned senior counsel for the petitioner has submitted that the land in question has been previously taken over by the state for the for setting up of an army camp. And the initial notification was issued under the Land Acquisition Act, 1894. Full stop. While the payment of compensation was not settled under the said notification, the government of Arunachal Pradesh, through its commissioner within bracket land management, issued a notification number LRE-5723 of 2014, dated 26/2/2014, under section 10 of the Balipara/Tirap/Sadia Frontier Track Jhum Land Regulation, 1947, in respect of the same land, plot of land at location Denning, DENNING, Denningham, for 69.76 acre. That is A. Next B. HQ 82, capital M, small t, full stop. Brigade, BRIGADE, Lohitpur, for land measuring 53.00 acre, and within bracket C, Shivaji Nagar, separate words, Shivaji Nagar, in respect of land measuring 120.08 acre. So it is submitted that pursuant to directions issued by this court in WBC 50 within bracket AP of 2021, decided on 24/2/2021, the district, the deputy commissioner had passed an order dated, what is the date of the order?
19/5/2022.
19?
19/5/2022.
2022, in connection with proceedings of LRE-5723 of 2022. And concluded that The matter of ownership has already been disposed of by the district administration in the year 2011. And accordingly, the representations for inclusion of name of the present petitioners as beneficiaries was not considered and the matters was disposed of. First of the said order is under challenge in the present writ petition. Post of the learned senior counsel for the petitioners has submitted that while disposing of the said proceedings, the acquisition by notification dated 26/2/2014 was not at all considered. Next para. Referring to the affidavit in opposition filed by the respondent number 4, the learned additional senior government advocate has also reiterated and referred to the stand taken in the decision of the Deputy Commissioner Lohit District in his order dated 19/7/2022. 19/7/2022. 19/5/2022. Full stop. Next para. Having regard to the herein before referred notification number LRE-5723/2014 dated 26/2/2014 within bracket annexure 4. The court is inclined to put a query to the learned additional senior government advocate as to whether the state admits the issuance of the said notification. Full stop. The said query is also directed to Mr. D. Kamduk, learned standing counsel for the Land Management Department. Full stop. On the next date, the said respondent, the respondent numbers one and 4 are put to notice to respond to the court query. Full stop. Similarly, the respondent numbers 2 and 3 are also put to notice to respond to this court query. Next para. In the meanwhile, the parties are permitted to exchange their affidavits. Next para. List. We are fixing after 4
Only
weeks.
they
We are
will
not
not-
giving a date.
Right. They will not release they will not pass an award. Otherwise, are they all infractions? It will be. We said
Definitely
not
they
to
would not-
release the complaint amount interim prayer at page 46. 46, we made a prayer. At 46 in the interim.
No, if this
46.
is not even settled, they would.
They will not settle it. That's the whole thing. Not to in the interim, it is prayed. They also will not to release the complaint amount.
Okay. Next para. The learned senior counsel for the petitioners is prayed for interim relief. Full stop. Issue notice on the prayer for interim relief, which is also returnable on the next date of listing. Next para. In the meantime, until the next date of listing, comma, the deputy commissioner, comma, Lohit district, yes, Teju, shall not release the compensation amount to any beneficiary without the leave of the court. I'm deeply honest. Next para, the petitioners shall produce a certified copy of this order before the said authority to bring the order to to its notice. I'm deeply obliged. Yes, we find some question mark in your, you have a very expressive face. Anything you want to say? Okay. Deeply obliged. You said nothing personal. I just want to keep the environment lively. Correct. Yes. What is this matter about?
Yes, my lord, this is a part hard matter. We just submitted by challenging the
Just a moment.
order of the deputy commissioner. Imping order. DCTS,
No, let this
ICC.
matter come. When is that matter listed? Ms. Rajan, this 1 or 2 days back, you took up this matter, Art of Living land. When it is fixed,
It is that matter, Lordship. I'm not getting.
oh, this is the case.
Yes.
Okay, this is the case. We heard on that.
Yes, yes.
yesterday. Okay,
Day
okay,
before yesterday.
okay. Yes,
My lord, here I was submitting my challenge, challenging the legality and validity of the deputy commissioner order, where he has decided the right and title in the land dispute of 2 private individuals. That is, one is Art of Living and one is petitioner. That is me. That is, and I'm also challenge put to the issue regarding the LPC issued to the Art of Living as per the Eastern Bengal Regulation Act 1873 and also as per the Land Settlement and Record Act 2012. And also I have made challenge. I have a objection that the as per Civil Code Act 2021, the deputy commissioner cannot have the authority or right to decide the title and rights of the private land, except the civil code.
yes. Yes.
No, no, my lord, I was expecting that you are.
No, no. I'm not putting a question. I'm hearing you. Complete your submissions. Complete your submissions.
Oh, my lord, I was submitting the legality and validity of the deputy commissioner agreed by the deputy commissioner order.
Yes.
On the ground that the deputy commissioner has no authority, deputy commissioner or revenue officer has no authority to decide the rights and title of two private individuals in the land dispute of two private individuals. And also I have put to issue the non-APST as per the non-APST cannot possess the land possession certificate, cannot have the land possession certificate as per Bengal Regulation Act 1873 and Section 7 of Bengal Regulation Act 1873 and Section 123 of Land Settlement Record Act 2012. And similarly, in the recent past also,
Land Settlement Act.
in the recent past also, to the land LPC issued to the Muslim community for the masjid in the month of June 2024 also has been cancelled on being not permissible, but cancelled by the deputy commissioner. Then just I'm referring.
No, I'm not being able to follow. I'm not being able to follow. The LPC of the respondent has been cancelled.
No, just I'm referring the non-APST community, Muslim community was
That is
issued.
different. You
Just
please concentrate on the brief. Otherwise, I will not be able to understand. I was not following you. That's why. Yes. In this case, how do you say that the title is declared? Please come to that finding.
yes, my lord. My lord,
Just tell me
just
one more
to-
thing. Just
just-
tell me one more thing. In a 145 proceeding, a 144, 145 proceeding or 133 proceeding,
Yes,
if
status.
the deputy commissioner makes a mention that X is the title holder of land, will that order become illegal?
No, 145 CRPC, it will not be illegal. Is a title holder, whatever may be, status quo. Usually,
How does this
145 status quo is being maintained.
How does the
Just to-
situation change in the present case under Land Settlement Act?
My lord, here directly and clearly particularly in his judgment and order in page number 56, this last para,
Page number
56.
Yes.
It's not just I'm just to the point only, not to the entire para. Hence, the respondent party is occupying the said respective floors of land without any valid authority of law, and the said respective occupied land is under the boundary of above mentioned LPC land of the complainant party. It is admitted fact that their respective party occupied the plot of respondent Sri Bengia Talo and Lindung Tavam is a land of complainant party, and claiming the private land by any individual without any valid authority is illegal and not reasonable in the eye of law. Respondent party Sri Bengia Talo and Bengia Talo and Lindung Tavung is hereby directed to vacate the LPC lane to of art of living
Correct.
society AP Juling
Now,
Wagatara Itanagar.
Let us see Public Premises Eviction Act.
That is 2003.
Correct. Whatever act is it, I'm just asking you, Public Premises Eviction Act, Unauthorized Occupants Eviction Act. Now, please write a order, operative part of that order, without saying who is the owner of the property. Even if the government wants somebody is occupying a land illegally, Deputy Commissioner will pass an order under unauthorized occupants, this Public Premises Authorized Occupants Act. Now, please try to envisage an order without referring to who is the owner and to pass an order for eviction. Because I can't think. For an order of eviction, let us say tomorrow, somebody comes forcibly, you are in court, somebody goes and occupies your house. Now you use these different acts to get him evicted. Now please tell me, how can an eviction be ordered without prima facie finding that who is the owner of the land? That's not a declaration of title. You see, he's not declaring it. He's just saying that he is the owner. Declaratory rights are only given by the civil court. So please tell me, if somebody occupies your part of the land, please try to write an order without saying that you are the owner, Mr. Nibo is the owner, and therefore you will evict you. Please try to think of an order, because I can't think.
My lord, here simply what I understand is wrong and right has been decided.
No,
Out of
you see,
living, out of
one
living
by
is
one,
right,
you
and
see-
Bengatolo is
No, no.
I am the wrong, and
No,
he
no,
has
I-
the right. I have no right. He has decided. That is why I said it's title has
No,
been
please, that's why
decided.
tell me, I'm
That's
just,
as per my opinion.
no,
understanding.
that's okay. I'm just I'm changing the position. I am bringing you. Now you think of an order where eviction can be ordered by a deputy commissioner without saying who is the owner of the property. Now, therefore, tomorrow I can file an application saying that the High Court should be evicted because I am the owner of land. Now, how on earth will an evicting authority say that X should be evicted or the Y should be evicted? Prima facie finding has to be there. Even in 144 it is required. Even in 133 it is required. Under Public Premises Eviction of Unauthorized Occupants Act, that is required. Without finding that somebody is unlawfully occupying, that is not a declaration of title. I say that when I'm passing an order, even revision under 144 revision can lie before the High Court. So in High Court, when I confirm it or I disagree with it, the opinion of the district commissioner, deputy commissioner, but how will I write? I'm just trying to learn how to write.
My lord, by mentioning the name of the parties, that is, and
I will
speaking
just
about
say-
issues.
Okay, I will just say Mr. X and Mr. Y, and I find that Y is to be evicted. Only that line. My satisfaction will be recorded as how? There are two parties to a dispute. Both of them lay claim to the ownership of the land. But since I cannot declare title, I will say I find that Y is liable to be evicted. And you think the order would be okay?
Just, my lord, just only this much was my submission.
No,
That
I understand, but we respect you. That's why we are asking. It is out of
issues can
respect.
be issues can be repaired. Violation can be repaired. Issues can be repaired. Violation can be repaired if any against the rules or authority, and the parties should be definitely repaired. But that decision, who is right, who is wrong, has to be made by the civil court. That is what I feel.
No. The state legislature in its wisdom has prepared
Declaration
an
of
act. The state legislature has prepared an act. If there is any other authority who can evict, there cannot be a statutory bar not to evict.
And my lord, one more submission in addition to this.
Just now, let me ask you another question, just to understand the scheme of law. Now, can somebody go, or rather can we ask him that whether the deputy commissioner can come to civil court and then say, X was my employee and we gave him a quarter to stay, he has overstayed. Therefore, please evict him under Public Premises Unauthorized Occupants Act. Is it available to the deputy commissioner to come there? To civil court, ask for eviction?
In this
He
regard,
cannot because there is an act.
he has the act, he has the
He
authority
has an act.
under
Therefore, if there is an act and if the deputy commissioner passes an order, how is it illegal?
Yes, my lord, deputy commissioner, if the act is passed on the as per the provision and authority,
No.
there's no wrong.
We don't find. Then you used another word. What law you referred? You referred to an act
Uh,
that it is impermissible for the
eighteen seventy-three, my lord, section 7 of 1873.
Which act? What is the name?
Bengal Eastern Regulation, Frontier
Bengal Eastern
Regulation Act.
Okay, which volume will I find it?
Volume 1.
Volume 1.
Well,
Which provision?
7, my lord.
Okay, where is your statement that the state government did not give a sanction?
The government may also by notification in the Gazette extends the provision contained in this section to any class of a person natives of the said districts may from time to time in like manner cancel or very much extension. It shall not be lawful for any person not being native of district comprised in the preamble of this regulation to acquire any interest in the land or product of beyond the inner line without the sanction of the state government or such other officers as the state government shall appoint in this behalf.
Mr. Nebo, please tell us. Let us assume that the respondent is not authorized to hold land. Correct. But does it give you an authority to encroach the land? He will lose land that is something else. It's a different way. Now, let us take an absurd example again. Non-citizen without inner line permit enters into the state of Arunachal Pradesh. Correct. Now, it is for the state to arrest him and to take action against him. But can a third party say that, no, I will evict him?
No, my lord.
Somebody is walking on the road, you catch hold of him, ask him his LPC is not there, you say that, no, I'll go and throw him out. And you go to that, take him into your vehicle, go to the check gate and throw him there.
No, my lord.
Why?
There is a authority to do so. There is a
So here also
authorized
same
authority.
thing. If somebody is an unauthorized resident here, you take action against him, put him to jail, but you can't encroach the land. All counts you fail.
And my lord, what about that Land Settlement Record Act 2012, section 123?
2012 shows that act. This is 2000 act. You're saying 2012 act. What is that?
Yes, rule, my lord, rule 2012. Not act.
2012.
Arunachal Pradesh Land Settlement and Records Rules 2012.
Where is that? Where will I find it?
Paragraph 123.
No, where is that act? Rules? Which volume will I get it? Which volume will I get it?
Allotment of land, eligibility of
No,
land.
which volume will I get it? आपके पास भी होना चाहिए. नहीं तो बना के रखिए, ये तो हमेशा लगने वाली चीज है ना, नोट करके रखिए. Yes, which provision?
123, my lord.
123.
In 123, there's a certain clause there, sections. First, eligibility of land allotment. Firstly, number one, a person who is a citizen of India and a indigenous Arunachal Pradesh scheduled tribe, APST, shall be eligible for allotment of land in urban and rural areas. This is the basic criteria.
In the proceedings before the Deputy Commissioner, where is your reply?
My lord,
In the proceedings of the before the Deputy Commissioner, where is your reply?
my reply.
Yes.
My lord, this particular order, which is the impugn order. It was first we were summoned and they have had on the same day and copy was served, copied all the record was served in the same day. No opportunity was given.
I'm asking you this question because this is a writ petition to challenge the order of the Deputy Commissioner.
Yes, my lord.
You have not put the challenge to the allotment of land in this writ petition. We can't divert from one issue to another.
My lord, Deputy Commissioner.
No. What are we hearing now?
My lord.
We are hearing now a challenge to the order of the Deputy Commissioner. You say that the Deputy Commissioner, you were not given an opportunity of
my lord,
filing an objection.
I got
Therefore,
I got the point.
this point was never taken before the Deputy Commissioner. Now, in this writ petition, can we jump into the question of validity of the land allotment when there is no such prayer made in the writ petition?
Writ petition, my lord, I have made.
Where is that?
Passing and setting aside of order passed by Deputy Commissioner cum Revenue Officer Itanagar was arrested also by petition case number ISC was order dated 16/6/2000 in arts and immediate cancellation of LPC so and so dated 21st September 2011 LPC number DCML.
Now you have given me a very good handle. You have given me a very good handle. Now please tell us, there is a valid gift deed.
Yes,
Correct.
last time also we have already mentioned, you have referred.
If there is a valid gift deed, can we set aside a gift deed in a writ petition?
Right, correct gift deed.
No, whether this is right or wrong, there's something else. But there is a gift deed. Can I set aside the gift deed? Can I touch that gift deed in a writ petition? Answer would be no. If the gift deed is valid, then if the land is occupied by the donee, can I say it is bad?
No, my lord, that is correct.
Then if you want that to be cancelled, you approach the appropriate authority. It can't be done in a writ petition. There's a simple answer.
Yes, that is so, but my lord, this Google map, whatever boundary is came from the LPC and LPC, the Deputy Commissioner, which is the impugn order passed on 16/6/2022 was based on the LPC. So that is why based on the LPC records, that is why I was compelled to refer the LPC also.
LPC. Please show us the LPC. Where is it at? Where is that LPC?
In their order.
No, LPC, you are challenging it. Where is that LPC?
LPC, my lord, it is in at page number 60, my lord.
60.
Yeah, of the writ petition.
That's all.
60 and 62. This certificate is issued
Correct.
based on the
Now when you show
deed of
me a,
gift.
now when you show me a document and I read it, your entire edifice of entire arguments done so far is lost. Please read the land position certificate. Read the contents. Read the contents of this certificate. Only 2 lines. First 2 lines.
That below one from top.
This is to certify.
This is to certify that the land area measuring so and so meters of the land described below is in art of position. Arunachal Pradesh Society at Jolang, Itanagar.
No, don't be so fast now.
Oh.
The art of living, comma, Arunachal Pradesh Society.
Art of living, Arunachal Pradesh Society.
So it's comma. Without comma, you don't read Arunachal Pradesh Society. Art of living, comma, Arunachal Pradesh Society. Therefore, it is registered under the Arunachal Pradesh Society Act.
Yes, my lord, could
Right?
be. Could be.
Right?
Could be. Yes, my lord. I have no.
Then your entire edifice of the argument is lost.
My lord, art of living is a branch, art of living of the main branch, which is established in the Arunachal Pradesh.
You see,
They can come have the in lease deed for 99 years.
I have got no personal knowledge of what is happening. I am just reading it and I am translating it. I am reading it and I am asking you questions. Here it is.
Art of living is run by
No,
Sri
now-
Ravi
now you
Sankarji.
see, if there is someone who's registered in Arunachal Pradesh. Now let us say there is a company, ABC and company registered office at Arunachal Pradesh. Are you saying that it can't exist?
No, my lord, if the land person certificate is valid and can be allowed, so I have nothing to object, but has to reflect in the order, that's all. And because this is the another case where the masjid, Muslim communities masjid's construction has been stopped and cancelled. This LPC was only being non-APST. That is also in Arunachal Naharlagan.
You show us that this is a registered society. And it is for the Masjid Society to come and agitate that they have been wrongfully evicted.
Here it is registered society is not
So
yet.
then, if somebody is a non-APST, definitely section 10 invoked with all means. But once they are registered, either you say that no firm, no company or no society can exist in Arunachal Pradesh except for physical citizens. They cannot be an incorporated citizen in the state of Arunachal Pradesh.
What I was plainly believing was that other citizen can enjoy, possess the land on the strength of lease deed, not on the strength of LPC or allotment. This is my understanding.
I don't think we have to ask anything to the respondents unless they want to say something specific. Yes, Mr. Kamdok. Yes. I have they've got the book. The book was there, we got it.
Not there. Of course, these rules, it refers to allotment of the government. We are dealing with private.
We understand. So it doesn't apply.
Yes, my lord, they also have submitted were governed, the issues and governed by this memorandum issued by the government of Arunachal Pradesh. But then, my lord, wrote this rule, my lord. This, my friend is saying that no society can be given this allotment or this, my lord, it could be wrong. My lord, may kindly come to rule 123, my lord.
Rule 123.
Yes, my lord.
Eligibility for allotment of land.
123, sub rule 5.
5.
Yes, my lord.
No firm or company or industrial unit which is not authorized by the government of Arunachal Pradesh and registered under the Registration Act, extension to Arunachal Pradesh subject to, oh, right.
Yes, my lord. But I will try to, my lord, submit from this several files there, my lord. It says, my lord, if any company is not registered within Arunachal Pradesh, he will not be given the allotment nor the sales, my lord. Since, my lord, the art of living is a registered society, therefore, they can be given this either allotment on lease or LPC can also be issued in them. So since my friend is harping on this issue that since this society is non-APSC, this headed by non-APSC, so therefore this society cannot be given the allotment or permitted to this run.
So it does not apply to allotment because it's a gift.
My lord.
Okay.
Gift, my lord, that is why my lord in the very outside matter I have submitted this rules govern the land allotment of the government. Although but from here we can get draw inference matter. This talks about government, but then LPC also my lord, can be given to the society which is duly registered in the state of safety. So LPC is issued on the basis of gift given by Soma to this other person. This in fact, since it is a registered society matter, it has a juristic identity. Therefore, we can always have the privilege of this having the LPC or land allotment. That's not something.
No, if
Yes. Let them complete their part. Yes.
Your Lordship. Your Lordship, may I read page number, read the impugned order as next by the petitioner, Your Lordship, in their petition. Yes, page 2 of 6.
Page
Page 48, Your Lordship.
of the
Of the petitioner's petition, Your Lordship.
read petition 48.
Page
Yes.
48, Your Lordship, the bottom,
Yes.
bottom paragraph, Your Lordship, last paragraph. Further, learned counsel submitted that it is admitted fact that his client, Shri Bengia Talo, occupied the plot of land without authority of law and prayed for at least 2 months time period may be given to his client for self-vacation of occupied land since the monsoon rainy season is running, Your Lordship. This was submitted before the, Your Lordship. That is why the
my lord, this has been
Let him complete.
okay.
Let them all complete.
Yes, yes.
in consequence to this submission, Your Lordship, this
Don't take
order
away
has
the-
been drawn, Your Lordship.
Don't take away the privilege of being able to smile in court. Yes,
My case is here.
your case rests here.
Yes, Your
Very good.
My lord, in this regard,
There are two more.
okay.
There are two more. That's why I said, don't take away the privilege of having a smile here. Yes.
Furthermore, Your Lordship, the petitioner counsel, he himself has accepted that the fact that his client is an encroacher. Your Lordship.
Correct. Correct.
Yeah, please, my lord. I'm
Yes.
for art of living.
Yes.
My lord, in my affidavit filed by respondent 5, in page 48, lordship will find the certificate, the society's registration certificate.
Pardon me, where?
Society registration
Where?
certificate of art of page 48 of my affidavit in opposition. This is the art of living with its headquarters at Itanagar, Papumpara.
48.
48 of my
Right,
affidavit.
Right.
This has been registered under the Societies Registration Act, Extension Arunachal Pradesh, 1978. Section 3 of the Societies Registration Act Arunachal Pradesh. Moreover,
Yes.
moreover, Lordship, art of living is not only, it's not only with people from outside members. In fact, the president is a local person. President itself is a local person. That also I have annexed. No, Lordship, nevertheless, the stand taken by them here regarding the cancellation of LPC, that is a different matter altogether, and that was not what was before the Deputy Commissioner. Before the Deputy Commissioner, Lordship may see the whole order. That was not his stand before the Deputy Commissioner. The only issue was that of encroachment. And also, Lordship has seen the LPCs. In one of the LPCs, it's 35,000 square meters. There are two LPCs dividing from the road on both sides. This art of living was gifted with the land by 4 persons. So that is why there's a huge plot of land. So there are two LPCs. One is, I think, 35,000 square meters. Another is 33,000 square meters. The land that he's occupying is only 600 square meters. So he's saying the whole thing should be cancelled and all, but these things were not an issue before the Deputy Commissioner. In any case, what Section 7 of Bengal, that 1873 Act says is that any person from outside cannot own without the sanction of the government. So that means if the government has given the authority, then why not? It is stated in that way, Lordship. But in any case, that is not an issue here now, because if the issue is of LPC that was not raised, it is not the forum to question the LPC. If the LPC has to be questioned, if anything has to be done, that has to be decided by a separate proceeding, not through a writ proceeding. So that is my humble submission.
What is that proceeding? Under which law?
There is no particular law, but what they usually do is, Mr. Kamto will be the best person to say that, but the Deputy Commissioner is the person who is to cancel if any cancellation could be done. But not in this manner, Lordship.
Okay.
In any case, there was not his case before the Deputy Commissioner. Obliged.
Yes. You're for?
Section 7. Section 7. Donor of the land.
Donor.
Donor of the land.
Okay, okay.
In this case, briefly, two impugn orders has been issued, as well as two LPC and a gift deed.
The donors are 6 and 7.
6 and 7.
Okay, right.
So, page number 58. This system of gift deed.
Page
58.
58.
58A of writ petition.
The 8. Yes.
Contention or part of the petitioner is that this gift deed doesn't bears the signature of the Tony. Or that cannot be a ground because section 123 of the Transfer of Property Act, it says the donor sign, it has to be drawn on signed by the donor. So this is first point. Second point, if this instrument of gift deed, if it is illegal, it can be challenged or it can be cancelled by invoking section 31 of the Specific Relief Act. So all those aspects cannot be decided in this writ proceeding. First thing. So therefore, this gift deed has been executed in a very legitimate manner, and subsequent to this, this duo LPC has been obtained. And this impugn order, which is at page number 47, as well as will find at page number 57. This order has also been impugned. This order is, it is in the form of eviction order. Page number 57.
Page number?
57 of the writ petition.
Yes.
It is.
Yes.
So, my lord, my contention is, my lord, London DC, my lord, has proceeded under section 145 of the CRPC while passing the impugn order, my lord. Though, my lord, 145 has no power has been conferred to the district magistrate, my lord, for issuance of any eviction order. But, my lord, this then settlement and record check, it has, my lord, to some extent, my lord, has conferred some power to the deputy commissioner, my lord.
I'm not following you.
My lord.
Please come closer to the speaker.
This impugn order, my lord, it has been passed under section 145 of the CRPC.
How do you say that?
There is, my lord. So, my lord,
how do you say that this is 145?
Because, my lord, initially, an order was taken. My lord, what happened is, after donating the land to the out of living, my lord, some portion was left over. So, initially, my lord, this petitioner, he encroached into my land. Therefore, my lord, I lodged a complaint. And according to my lord, it was taken cognizance of, which is a annexer C series, page number 35. My lord, will find this order under 145 CRPC, read with 107 of CRPC was invoked. This complaint goes by me. And subsequent to that, my lord, again, the out of living has also lodged a complaint. It was clubbed together.
No, that can't be presumed. That can't be presumed. You see, page 35 you are showing us.
My lord.
The name is there, Mrs. Nabam Yaja
Yes.
versus Bangyo Talo.
Yes.
Now look at page 57. In the matter of art of living, Juliang versus Bengia Talo and so and so.
Yes.
So it can't be 145 proceedings. You can't presume that.
There is. So, my lord, the contingent of the petitioner, my lord, those cannot be decided, my lord, in this writ proceeding, my lord.
Because Ms. Danjan is not saying that we did not move the deputy commissioner. She does not say that. So once deputy commissioner is moved and he has passed the order, and that this order is passed in a proceeding initiated by Art of Living,
Right.
that cannot be questioned at this stage.
My submission only confined to the, my lord, Gifted and the LPC, my lord. And being a donor, my lord, out of my willingness, my lord, I have donated, my lord.
Okay. Yes, Mr. Nivo, in your reply, what do you have to say?
My lord, regarding saying that respondent number 2, counsel for the respondent number 2 has said that I have myself has sought 2 months time for the vacation. That to that part, I have already made clear in my writ petition that has not been that was not my submission. That is made in my writ petition, page number 19. I have clarified number 1. Page number 19. In the top, which starts from actually page number 18, but the page number 18 last part, 2 month time may be given to his client for self-vacation of the occupied land. Season is running. Is concocted, which has been never stated before the said authority. Well, that I have already cleared. Now, my lord, without much taking time or the precious time of the honorable court, I would only say, if the
You know the difficulty. Few moments back, I told that when I read everything. And I also indicated that I also read affidavits. It's an invariably thing I do. Come to your own affidavit. Statement in paragraph 10 is true to your records. Now, what
Yes.
is the record to show that you are not given said there?
Paragraph 10.
Page 26 of your affidavit. Para 10 is a matter of record. It is sworn in the affidavit that whatever you have stated in para 10 is a matter of record. Now, where is the record? So your affidavit is gone. Your para 10 statement is gone. Invariably, I will read in affidavit. Para 10 is true to your records. Being matters of record are true to your information. Now, what is the record?
Record is para 10. To the para 10, it is reflected the verification site and the Civil Court Act dated 12.
So,
that
no,
was
your
the
statement
annexed.
that you have not
So
said
all
that.
the annexed records are records.
No, that can't be. It may be your interpretation, but we can't accept that. Para 10 that I have not stated this is a statement of fact. I have not stated this is a statement of fact. In para 10 it's given. Para 10 is true to your record. Now, where is that record that you did not say that? It could have been a statement made based on knowledge or submission,
Yes,
but it could
that,
not
that
have
was
been.
my submission.
No, I don't
Submission.
know. You
Submission.
say something and I
That
take
is my
it.
submission because that particular word I have not stated that cannot be brought to the record.
But it's not a matter of record. So that goes. I invariably do it. That's why I made that statement that I read even affidavit. It's my bad habit, but I waste some part of my time, but I can't overcome that bad habit.
I have stated so, but that is not put to the record. That is true.
Okay.
Because that is not possible also.
Okay. Mr. M. Devon, counsel for the petitioner.
My lord, last
Yes.
small submission. My lord, is the authority has passed in the capacity of revenue officer, deputy commissioner come revenue officer, and I don't see also any provision for the eviction under the provision of Land Settlement Record Act 2000. So at least there must be provision to do, though it may not be a final decision or the decision of the decided the case. I said, and that if it is not decided, at least for the eviction portion, there should be some provision under by virtue of which capacity the deputy commissioner can do. That also must be made clear.
Yes, where is the power to evict? Mr. Kamlu, where is the power to evict?
There is especially
Last occasion also there's a
that would say my lord, but then my lord.
rule should be very clear to pass such any order.
Yes, my lord. Section 82, my lord. In my book, it is page number 245.
But where is the substantive power to evict?
Expressly provided in the Act manual. Section 79 also gives the power of the court to revenue officer manual. Section 79.
79.
79. And its name may not be the revenue officer has the power to use the force matter. Use during the course of eviction also matter. Right?
No, power cannot be presumed. It must be vested. You see, these powers are required for use of force for a different reason. Because definitely when this is a Rent Settlement Act, you will have power, the revenue court will have power to sell the defaulting estate for realizing land revenue. This has power?
Right.
Under this act, if it's a revenue court, it will have power to sell land of defaulting estate for non-payment of revenue. Does this have it?
My lord, in the rule, my lord, government can, my lord, of course, auction the land, my lord.
No.
It's provided.
In this act, whether or not a defaulting estate can be sold under this act.
No, my lord. I don't find such thing, my lord.
If it is non-settlement, why revenue? Why there is a revenue court? Why on earth would somebody constitute a revenue court when no revenue is collected? And what will the government do if revenue is not paid?
My lord, we have not seen such type of cases.
No. Seen and provision are two different things. You may not have seen it.
My lord, if revenue is not paid, my lord, is provided, my lord. The allotment will be cancelled, my lord.
No.
And
Allotment doesn't cancel. If the lands are resumed, then the defaulting estate are sold. That is what the normal tenor of the land acts should be. Why there is a revenue court at all if there is no revenue? You see land revenue, section 15, everywhere you refer to land revenue. It has to be.
Recovery of this land revenue is also provided, my lord.
Yes, 62. Distance sale of the movable property of a so and so. After the sale of immovable, what is 63? It does contain, has to. Otherwise, there is no purpose of a Land Settlement Act. 63. So therefore, what happens is that land of A is being sold, B comes into possession, and therefore the revenue officer will have power to evict B from that land. That is where those powers are. You can't give them power to evict. It will be power of the vested only with the civil court.
That is what I have, my lord, I have, there is, the power is not expressly provided in this agreement.
No, it can't
Then
be.
we say that my lord, the deputy commissioner will have the power to evict.
Then, Ms. Dejan, you have to go to the civil court. You can't have this act for eviction. Anything you want to say on that, Ms. Dejan?
Lordship, it is for the deputy commissioner to answer this, but so far as we are concerned, in page number 45, this is the summon given to, in the case, initially when the case started, this is a summon given to the petitioner and two other persons. Lordship may see at the top of the writ petition, office of the deputy commissioner. Then next page, Lordship may see page 46. In the court of deputy commissioner come district magistrate. This is the order after the summons when they had appeared. Then thereafter is the impugn order wherein revenue officer is mentioned. There is nothing in the order to indicate that this.
Also, power is not there.
Yes, there is nothing in the orders to indicate that this order has been passed under the Land Settlement and Records Act, because the power he seems to be exercising in page 46 is as deputy commissioner come district magistrate. Then only in the page 47 revenue officer is written. So I'm not in a position to say anything on this because it seems to be mixed up. For as far as I'm concerned, we had only made a complaint that they are encroaching our land, and this is how it came to pass. Now, because of it could be a typing mistake, we don't know that, because in only the final order, the revenue officer.
This officer is using 4 titles. Number
Yes.
1, he's a revenue officer. Number 1,
Deputy commissioner.
He's a deputy commissioner. He's a collector.
Yes.
And he's a district magistrate.
Yes.
So it's an interchange of words.
Yes, it seems like that to me because of this.
If the names are interchanged, it doesn't make an order illegal.
That's what I'm saying,
It's
Lordship.
not illegal, but it doesn't have power to evict. So that goes.
Although it is not mentioned in the orders.
Petitioner also had Mr. D. Kamduk Leonard. First will be government. Who will be government? Miss Ete was here. Miss G. Ete, Leonard, government advocate, appearing for respondent number. You're for the government?
Yes, Your Lordship.
Oh, achha. You're appearing for the government?
Yes, Your Lordship.
Okay.
I'm appearing for this.
Miss Sangeeta.
Sangeeta.
Miss P. Sangeeta, government advocate, appearing for respondent number 1 and 2.
Your Lordship, 1 and 2.
Mr. D. Kamduk, Leonard, standing counsel for the land management department, appearing for respondent number 3. Okay, Ms. Sangeeta, you will also appear for respondent number 4.
Yes,
He is the extra assistant commissioner made by name.
Yes, Your Lordship.
Okay, now you further down, for the time being, you say 3, Mr. Kamduk. Ms. and agent and counsel for respondent number 5. And Mr.
Lordship, I'm not appearing for respondent number 4. I am not appearing for respondent number 4, Your Lordship. Respondent number 4, Your Lordship.
Ha.
Yes.
You'll be appearing for her, him?
I'm not appearing for her, Your Lordship, because it is given by name, Your Lordship.
No, we'll tell you why, because this is an official act. Malice is nowhere written in this petition. So that's why I'm not passing an order right now, but I'll through the order of the court, you will be appearing for this person. Your name, please? G. Riba, learned counsel, appearing for respondent number 6 and 7. Next para. It is noted that the respondent number 4, though implemented by name, is the extra assistant commissioner and he otherwise has ex-Lieutenant Commissioner, comma, Capital Complex, comma, Itanagar, full stop. As we do not find anything in this writ petition alleging malice against the respondent number 4, comma, the respondent number 4 has acted in his official capacity to pass orders and to implement the directions by the Deputy Commissioner. Full stop. Accordingly, we request the government advocate to also appear for respondent number 4. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, comma, the petitioner has assailed so far the other members of the bar are concerned, I may not be able to take up any other matter. I would not have time. Mr. Baru, you are coming from outside. Which matter? 24, 25. You fixed it as per his convenience. You come this side and take a date of convenience. If there is any interim order to be extended, please tell the court master. If in any case there is an interim order to be extended. No, that he will take care of. But if there is any case where interim orders are to be extended, please tell the court master. Okay. By filing this report under Article 226 of the Constitution of India, the petitioner has made threefold prayers, 3-fold prayers. Number 1, for quashing the order dated 16/6/2022, passed in the proceedings of the Art of Living Society versus Sri Bengia, BENGIA, Talo, TALO, and 2 others. As well as eviction order dated 9/8/2022, passed in the said proceedings. Semicolon. Number 2, for cancellation of LPC dated 21/9/2011 and LPC dated 22/9/2011, issued in favor of the Art of Living Society, comma, Julang, JULLANG, comma, Itanagar, within bracket, respondent number 5. Semicolon, and 3, number 3, the authority who had issued the LPCs referred above, and the magistrate who has put the signature on the sale deed on 23/4/2008 may be directed for necessary action as per procedure provided under the law. Next part. The case of the petitioner is that he is possessing a land measuring 600 square meter since about the year 1990. Full stop. in connection with a notice dated issues, issues notice pursuant to order dated 25/1/2021. In the proceedings under section 145 CRPC, petitioner had submitted a reply on 1/2/2021. So by order dated 8/2/2021, the additional district magistrate, Itanagar Capital Complex, by in the proceedings of capital CEO JUD -2282 2021 6527 -31 issued under section 145 CRPC, directed both parties to maintain status quo, and the land was ordered to be inspected. First of all, in connection with the said proceedings, the respondent number five society had submitted a prayer dated 17/2/2022. Full stop. Nothing is stated in this writ petition as to what has happened to the said proceedings. Next para, however, the deputy commissioner, capital, Itanagar, issued a summons dated 5/5/2022 to the petitioner to appear in the proceedings. And accordingly, on 9/5/2022, the petitioner appeared before the said authority, and while the case was fixed on 19/5/2022, as an interim measure, both parties were directed, or all parties were directed to maintain status quo by the deputy commissioner, district magistrate, capital, Itanagar. Full stop. Next para. Thereafter, the proceedings of DC-1 ICC -17013 oblique 13 oblique 2022 between the respondent number 5 and the petitioner and two others, comma, the deputy commissioner, comma, ICC, comma, Itanagar, hold that the petitioner and the other respondents in the said proceedings were occupying the respective plot of land without any valid authority of law, and they had respectively occupied plots which are under the boundary of the two LPCs referred herein before, which was LPC land of the respondent number 5. And then the petitioner herein and two others had occupied the land of the respondent number 6 and 7. No, not 6 and 7. Who are these people?
One who issued gift deed.
Oh, okay. And the land which was held by the petitioner and another was without any valid authority and illegal, and accordingly the petitioner and another you write the name, the petitioner, namely Bengia, Bengia, Talo, and another person, namely Sri Lidum, Lindum, Tabong, Tabung, were directed to vacate the LPC land of the respondent number 5 society on or before 7/8/2022, comma, failing which the same shall be evicted and restored to the respondent number 5 without any notice. The name of the third respondent in that proceeding was struck off. Thereafter, by an order dated thereafter by an order dated 9/8/2022, comma, the deputy commissioner, comma, capital, comma, Itanagar, directed the concerned EAC to carry out eviction of the encroachment done by the petitioner and another from the LPC land of the respondent number 5 within 2 weeks. Next one. Then counsel for the petitioner has raised a first objection to the effect that the deed of gift, by virtue of which the deed of gift executed by respondent numbers 5 and 6, sorry, 6 and 7, by which the respondent number 5 was handed over, the plot of land mentioned therein was illegal and could not devolve any property on the respondent number 5. Firstly, because the said deed of gift did not contain the signature of the donee, and therefore it is not an agreement. Full stop. Secondly, comma, it is submitted that the respondent number 5 society not being original resident of the state of Arunachal Pradesh does not have the authority to own land in the state of Arunachal Pradesh. Full stop. He said grounds of challenge, though should have been raised before the civil court, has been agitated in the writ petition. Full stop. Expressly, the said two grounds are not found to be of merit. Full stop. Firstly, comma, deed of gift cannot be held to be invalid merely because it is only executed by the donor. Full stop. A deed of gift cannot be equated to that of an agreement to make it a bipartite agreement. Full stop. From the copy of gift deed, which is annexed in the writ petition, comma, it is noted that in the second page of the said gift deed, comma, on behalf of the respondent number 5 society, the gift was accepted. Full stop. Secondly, comma, the learned counsel for the respondent number 5 has referred to the certificate of registration of the respondent number 5 society under the Societies Registration Act, 1860, as modified by the Societies Registration within bracket extension to Arunachal Pradesh bracket close Act, 1978. Therefore, the respondent number 5 society is demonstrated to be a society registered under the laws of Arunachal Pradesh, and therefore nothing is brought on record by the petitioner to show that a society registered in the state of Arunachal Pradesh is legally debarred to hold any property. Full stop. Next. Referring to the provisions of the Arunachal Pradesh, sorry, not Arunachal Pradesh, under the provisions of the Bengal Eastern Frontier Regulation, 1873, it is submitted that under Regulation 7, it is provided that it would not be lawful for any person, not being a native, to hold interest in any land in the state of Arunachal Pradesh. Full stop. This ground also has no merit because of the fact that, as stated herein before, comma, the respondent of 5 society is registered within the state of Arunachal Pradesh. Full stop. Next para, the third ground to assail. The impugn order a part of the order is that although it is recorded in the said order dated 16/6/2022 that the counsel for the petitioner had admitted the fact that the petitioner had occupied the plot of land without authority of law and prayed for at least 2 months' time period for self-vacation of the occupied land since the monsoons public rainy season is running. By submitting that in the writ petition, the petitioner has disowned the said observation of admitting to vacate the land. Full stop. The said statement is made in paragraph 10 of the writ petition, which is verified in the accompanying affidavit as a matter of record. Full stop. There is no record to sustain the statement made in paragraph 10 of the writ petition. Next paragraph. In this writ petition, in paragraph 10 of the writ petition, ten within bracket 1, say 10(1). 10(1) means I, I. 10(1). It is stated that such a statement was never stated before the said authority is also not acceptable because of the fact that in the order, it is clearly in the order dated 16/6/2022, it is specifically mentioned that such statement was made by the learned counsel. Full stop. Therefore, the statement made by the learned counsel representing the petitioner would bind the petitioner, as even in this writ petition, it is not denied that the learned counsel for the petitioner was not authorized to make such statement. Therefore, that part of the challenge to the order dated 16/6/2022 is also not found sustainable. Next para. What is your other ground? One more ground you took?
1873 and the Land Settlement Record Act as per this section 123.
Okay, and the next ground to challenge the Indian order is that under the Arunachal Pradesh Land Settlement and Records within bracket Land Settlement and Records bracket was Act 2000 and Arunachal Pradesh Land Settlement and Records Rules 2012. The respondent's 5 society is not entitled to hold land. Full stop. In this regard, the learned Standing Council for the Land Management Department has demonstrated that in the present case in hand, it's not a government land which is allotted to the respondent number 5 society. Full stop. It is asserted that if the society is registered in the state of Arunachal Pradesh, there is no bar to an allotment of land even by the government. Full stop. Moreover, it is submitted by the learned Standing Council for the respondent numbers 1 and 2 that in the present case in hand, it's not, no land is allotted to the respondent number 5 society, but the land is transferred to them by way of donation by respondent numbers 5 and 6 and 7. And therefore, the applicability of the said act and rules would not be on the said private land. Most of therefore, therefore, as the facts of this case is that the respondent number 5 was handed over land by way of a gift deed by respondent numbers 6 and 7, the said so-and-so Act 2000 and so-and-so Rules 2012 cannot constitute a bar for the respondent number 5 to hold the land. Next paragraph. Resultantly, no, not resultantly. Next paragraph. The learned counsel for the petitioner has also questioned the LPC issued in favor of the respondent number 5. Full stop. In this regard, the learned counsel for the respondent number 5 has submitted that normally LPC is issued by the Deputy Commissioner, and therefore all applications for cancellation of an LPC is entertained by a Deputy Commissioner. Full stop. She submits that the writ petition, the writ court should be slow in rendering an opinion on an LPC for which disputed questions of fact would be required to be entertained. Full stop.
My lord, may I please? The additional last point was that
No, Viral Kama, I'm not over yet. Full stop. In this regard, the learned counsel for the respondent number 5 appears to be correct in saying that the challenge can be otherwise or made in an alternative forum. Full stop. Accordingly, notwithstanding that this court had already dealt upon the important facets of the LPC, which relates to the right of a society to own land and the validity of the and non-entertaining of the challenge to the give deed. Come on. In order to maintain the judicial discipline of permitting the LPC to be challenged before the authorities, authority competent to adjudicate, we are disinclined to entertain the prayer number 2 made in this writ petition. Next paragraph. The last submission of the land council to the petitioner is that the deputy commissioner, ICC, Itanagar, is not authorized to pass an order for election. To stop. In this connection, the learned standing council for the land management department has referred to the provisions of section, what is it section? Use of 82, so section 82 of the Arunachal Pradesh within bracket Land Settlement and Records bracket close Act 2000. Read with section, one more section you referred. Read with section 79 of the said Act, which empowers the authorities exercising power under the said Act to be revenue courts. Full stop. Next paragraph. In connection with the said submission made by the learned standing council for the land management department, the court is of the considered opinion that in order to evict a person from a land, otherwise than in exercise of revenue jurisdiction, must be specifically vested. Full stop. In Full stop. Nonetheless, comma, be that as it may, comma, there is no substantive provision under the said Act of 2000, empowering the Deputy Commissioner to act as a civil court and order eviction. Full stop. In this regard, it may be mentioned that the learned standing counsel for the Land Management Department has further stated that under Section 79 of the said Act, the Deputy Commissioner is vested with the power to inquire into and decide any question arising for determination between the government and any person or between parties to a proceeding shall be a revenue court. Full stop. In the considered opinion of the court, comma, that is an essential empowerment because to the Deputy Commissioner as a revenue court, because in exercise of power as a revenue court, comma, the said authority is required to pass orders for demarcation of land and also to ascertain the position of persons over the plot of land, as the said authority is required to maintain the land records. Full stop. Therefore, mere power for redressal of disputes relating to all disputes between two parties cannot be read to empower a revenue court to order eviction in a land dispute, which is otherwise vested only on the civil courts. Next paragraph. There is no specific empowerment either under Section 79 or under Section 82 of the said Act which permits persons encroaching upon the private land to raise a dispute before the revenue court and evict such persons in summary trial. Stop. The court is of the considered opinion that insofar as the adjudication of disputes are concerned, the revenue court had the competence to decide as to whether there was an encroachment so however the revenue court would not have the revenue court is not vested with the power under the said act to act as a civil court and not a eviction. Next paragraph. Accordingly, the court is inclined to hold that that part of the order, the impugn order dated 16/6/2022, by which an eviction of the petitioner is ordered, is not sustainable. First of how, insofar as the other finding recorded in the said order is concerned, the same does not warrant any interference. Full stop. Therefore, up to the part where the Deputy Commissioner ICC, Itanagar has held that the petitioner is illegally occupying part of the land of the respondent number 5. Up to that part, the impugn order is sustained and held to be valid. Full stop. Only the part where direction is issued for eviction of the petitioner as contained in order dated 16/6/2022 and 9/8/2022 is held to be not in accordance with law, and therefore only the said part of the order is set aside. Full stop. Next, accordingly, insofar as the other part of the impugn order, whereby the Deputy Commissioner, ICC, Itanagar, has directed the petitioners to maintain status quo, shall is affirmed. Full stop. Accordingly, on violation of the order of status quo by the petitioner, it would be open to the Deputy Commissioner, ICC, Itanagar to take cognizance of such of violation, if any, and to enforce his order. That enforces that part of the order. Next paragraph. With the in view of the discussions above, this litigation stands party allowed. The extent as indicated above, most of the parties are left to bear their own cost. So revenue court I have decided, but there may be a possibility of some correction of the orders in that part. The order may be in variance when I ultimately sign it. That part needs some more refining. Oh, there's one more matter. Somebody's on video conference. So.
Item number 24 and 25.
Please, my lords.
Yes.
My lords, in these matters, my lord was pleased on the 20th of September to extend the interim relief till today's date of listing. If my lords could kindly extend that to whatever is the next date which suits my lords. Our suggested date would be 23rd October, given that my lord...
23rd is not possible because it's just after opening. We have many matters spilled over for that time.
Would my lords then grant me 25th? 25th? 24th or 25th?
No, take it on 28th, 28, 29, 28 or 30.
My lords, Bombay High Court, and so we go off on,
Just a moment. 29. Yes,
my lords, Bombay High Court and the Supreme Court then go off on Diwali vacation at that stage. So then would my lords give it sometime after 10th November?
after,
10th November, my lords.
okay. Yes. Can I have it on 25th then? 25th कितना matter fix है? नहीं, 25th, how many matters are there? Lot of matter.
My lords, any date in that week, 20th to 25th, whatever suits my lords.
No, this is not happening because they are all matters are spilled over. This last week was a vacation. 13th to 19th is a vacation. 20 is a Sunday, so it's opening on 21st. We have a lot of spillover matters that time. Okay, 10 after 10th, then we fix on 11th November.
Very well, my lord. And my lords would extend the interim orders.
Okay, due to positive time, matter could not be taken up today. Both sides are represented. So the counsel for the petitioner has appeared through video conference. Full stop. Interim order passed earlier stands extended to the next date of listing. Next list on 11/11/2022.
I'm grateful.